May it please your lordship.
Remind us. Remind me.
May it please your lordship. I beg to mention item number 17, admission matter, lordship. Can be taken up this matter for as a upgrade item, lordship? Because lordship, here petitioner has been convicted under 302. He is a juvenile, lordship, for 3 years imprisonment, lordship. His conviction order was upheld by the trial lordship, appellate court, lordship. Now this revision, lordship, only 3 years conviction, lordship. Can be taken up at 2, lordship?
Some matters are there. I don't know if it is possible or not. Almost 60 matters are there.
3 years conviction only, lordship.
No,
There is a
okay, we'll try.
idea of this.
May it please your lordship. Lordship, I am praying for listing of a BA, my lord, for tomorrow. As another case, my lord, arising out of same FIR, same forwarding, my lord, is fixed before your lordship as item number 23, my lord. Tomorrow's list, my lord. I am praying to take this matter, my lord.
May I please lordship? Item number 26, my lord, CD probably not there, my lord. But I am in team, my lord. 26, my lord. CD not
26.
Yes, ma'am.
CD not.
CD not received and the petitioner is an interim law. 8 August.
8 of August. Make it.
May I please your lordship? Lordship, I am for item number 11, lordship. Any detailed accommodation with the consent of both the party, other party, lordship. We both have some personal difficulty today, lordship. Today, lordship. Both the parties, lordship.
So basically you are for the petitioner.
I am for the petitioner. And respondent are also having some personal difficulty. I am also having personal difficulty. After 2 weeks, lordship.
According after
2 weeks, lordship.
after
Okay, interim order passed earlier.
interim was there. After 2 weeks, interim be continued to interim.
I'll jump back.
May please, your lordship. I pray for upgrade the matter item number 49. May be taken at 2, my lordship.
Sorry, it won't be possible. 49.
49. It is for consideration of IA, my lord.
I don't know if it reaches, it can be taken up. Definitely will take. I'm just marking it, but I cannot assure you whether it can be taken up at 2. Okay, just I'm marking it. I'm giving us specific note here in this case.
And then before rising, my lordship.
No, whatever, we'll try to.
Yes, my lord. Obliged.
May it please the lordship. Lordship, with the consent of other side, I beg to mention item number 16, my lord.
1-6.
1-6. Can it be taken up after 2 weeks, my lord?
You are for the petitioner?
I am for the petitioner, my lord. And there is an interim order also. My lord.
What is the IA for?
I, my lord, it was, we paid for stay of the proceeding, my lord, that has been granted by this honorable court, my lord. By the order dated 3/6/2024.
Already granted.
Already granted, my lord.
Okay, it will be listed after 2.
Interim may be continued, my
Interim.
lord. I am deeply obliged.
May it please your lordship.
Interim.
Lordship, with regard to item number 12, my lord, lordship, this matter may kindly be taken up after 2 weeks, madam. Item number 12.
Well, here, state is state. Apart from state, is there any other part?
Yes, my lord, there is, my lord. We have taken steps also, but they are not appeared.
Stop.
There is an interim order, my lord. There may be continued till the
It can be continued.
May I please your lordship?
Interim. 2.
May I please your lordship? I beg to mention item 40, lordship.
40.
40, lordship. Perhaps CD not received, lordship.
CD not received, lordship.
Petitioner or interim, lordship.
You are on interim.
Interim, lordship.
Interim PX should remind you. Yes.
8th of August.
8 of August.
Interim will continue till that.
Yes.
Master.
May I please lordship? I become mention item number 15, lordship.
1-5.
Lordship.
Consent taken, Lordship. I am for the petitioner, Lordship. Matter will be taken next week. Interview is there.
You are for the petitioner?
I am for the petitioner.
For the- After 2 weeks.
Next week.
Next week.
Next week.
Lordship, I am appearing for respondent, Lordship. Next week, any date, Lordship.
Any date may be fixed.
Date you want to fix it? It will be after 1 week. No fixed date.
Lordship,
After
urgency
one.
is there, Lordship.
Huh?
Urgency is there. Some urgency.
So, today was the listed for next week. Next week we are fixing it after 1.
Interview that
Fixed date.
earlier interview that may be continued.
Interim was there.
Mhm.
Interim we continued.
Pass on. If it is Lordship, I will mention item number 10 maybe withdraw, Lordship.
Item number 10. You want to withdraw this?
Yes, Lordship.
Your good name?
Islam.
Okay, it will be disposed on withdraw.
Yes.
May I please, Lordship? I beg to mention item number 48. Lordship, matter may kindly be taken out after 2 weeks.
48. You are for the petitioner?
Yes, Lordship.
Just after 2. Is there any interim now? No.
There is an interim.
Interim was interim we continued.
Lordship, kindly fix a date.
Pardon?
Kindly fix a date, Lord.
No, after 2.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention for item number 34, Your Lordship. CD was called for. I am on interim, Your Lordship.
Charge sheet has been submitted. Lordship.
You are on interim.
I am on interim, Your Lordship.
Please tell us this charge sheet number.
Yes, Lordship. Charge sheet number 82/2024, dated 30/5/24.
You are on interim.
Yes, Your Lordship.
We will
I am on.
extend your interim period till up to 10 days. And we have reported under track code below with an appropriate for pay that may be considered. So we are extending your interim till up to 10 days. Very good.
May I please, Your Lordship? I beg to mention item number 42, my lord. Matter may be passed over for today.
42. Matrimonial petition. You are for the petition.
Yes, petition.
You have not taken steps for the. Have you taken steps for the respondent?
No, my lord, I don't know. Ever discussed.
42 today. Office count of अच्छा just 23 ना. This is the last report I think 11 14 11 see. state, it is not the party, but additional PP appear, I don't know. State is not the party. Here it is the application for a and the rest of that. You are Miss
B does.
B does.
Yes.
Hard MS. You are paying for MS Stone?
T shown.
Hard MS. Office note. It is 1411. We have not taken and still respond. According to the response. You take steps within 3 days because since 20 most probably is pending from the year 2022 until now you have not taken any steps. Within 3 days take steps. It will be listed after 3 days.
May it please your Lordship. Lordship, today I filed an IA in BA number 2011 of 24, Lordship, for modification of an order, Lordship, on 15/7/24 passed by your Lordship. There is some modification need.
You have already filed.
Today I filed, Lordship, already filed. Let it went to
We come tomorrow.
today, Lordship, urgency. Petitioner is in jail, Lordship.
May I please, your Lordship? Lordship, I would like to withdraw the item number 14, Lordship. The matter has been settled amicably.
Settled already. 14. You are for the other side. You are for the petitioner.
Petition.
You are Mr.
PHO.
THO. Hard Mr. THO to fill an it is subject to the item that has already kept that very book. But petitioner does not put the case file according to most of the case. Prayer from
I beg to mention item number 20, Lord.
20.
Mr. L.R. Muzumdar, Lordship, is out of station, Lordship. Kindly action for 2 days.
LR Mujumdar.
L.R.
The NDPS matter. From my, is the NDPS matter or
Yes, NDPS.
we have received the scan copy?
Scan copy is in.
This actually, no, stop. It's the scan copy of the case report. It's the matter you want when he is out there?
Next week.
Next week. Next week, I don't know. Yes, next week can it be? 7-8 will be.
Yes, all right.
May I please, Your Lordship? My Lord, it's for my Lord listing regular bail, my Lord. Poxo matter, my Lord, notice is to go, my Lord. He is in custody, my Lord. So may I pray, my Lord, may be taken up tomorrow, my Lord. It's already filed, my Lord. Poxo matter, my Lord.
Tomorrow. Day after tomorrow. Let's
Lord.
day after.
Deeply blessed.
May I please, Lordship?
Yes.
Lordship, here page 8, Lordship. This is type copy, Lordship. And vernacular page 11.
Yes.
Yes, Lordship. With the most respectfully beg to state that at the present, I, along with my wife, 2 sons and 2 daughters, have been residing in a tent on the roadside of the Morikolong MD Road in the district of Nagaon, Assam from almost 15 days for my business purposes. On 21/5/2024, midnight at about 2:30 a.m., when we are sleeping under the tent, the below named accused persons brought a Bolero and a small Maruti car and tried to forcefully take away of our elder daughter, namely Jyoti Singh, aged about 19 years. When along with my elder sons, namely Muri Singh, tried to rescue her, the accused persons attacked me by using like iron rod, and I sustained injuries on my head and also pushed to my children and fled away on being took my daughter, Lordship. Lordship, Lordship, accused number 4, that is the present petition number 1, Lordship. And petition number 2 is the not named accused, Lordship. Here, Lordship, complainant as well as the petition number 1, Lordship, they are all other relatives, Lordship. Lordship, their Lordship belongs to community, Lordship, some called Banjar, who are residing, Lordship, in the roadside, Lordship, or temporarily, Lordship. So, Lordship, they are relative, Lordship. Whatever the Lordship, their allegations, Lordship, the background of the case is different, Lordship. Lordship, the girls, who is the Lordship?
When they are in custody.
Lordship, since Lordship 26/5, as on date, Lordship, 52 days, Lordship.
Is there any order or anything where from we can come to a conclusion that the girl has already been recovered?
No, Lordship. Lordship, not recovered, Lordship. That's because, Lordship, it's Lordship kindly come to page 13. No, Lordship. Page 13, not, it is 17. It is rejection order, Lordship. The court below rejected this bail.
No, that's okay. I'm talking about whether the girl has already been recovered.
Lordship, till today, Lordship, I have no knowledge. As because, Lordship, so far my knowledge, Lordship, that the girl was along with his boyfriend, Lordship. That boy also is my relative, Lordship. So,
with whom she eloped?
Lordship, that girl's, Lordship.
No, that girl with whom she eloped.
That the Sunu Singh, Lordship, that name is there, Lordship. I have stated. Lordship, paragraph number 9, Lordship, page 4, Lordship.
No, I'm simply asking you with whom she eloped.
Lordship, that is Shunil, namely Shunil, Lordship.
Shunil.
Who also my relative of the present petition number 1, Lordship. I have categorically mentioned, Lordship, in paragraph number 9, that, Lordship, that girls has been, Lordship, their marriage was fixed at about 4 years ago. After that, Lordship, what happened? The relations are developed, but Lordship, their father.
Okay,
yes,
she may have played away with that guy, and they are behind the bar for a considerable period also.
Yes, Lordship. Yes.
That is understood, but I'm just asking whether the girl is recovered or not.
No, Lordship. Till today,
not
Lordship.
recovered, then obviously.
Not yet recovered. Not yet
Lordship,
recovered.
till today, I have no knowledge, Lordship. That's because, Lordship, that boy, Lordship, and girls, where they were guns, Lordship, no knowledge, Lordship.
But during the by the time of investigation, IO may have some information that will reveal by the CD only, because we don't have anything.
Yes.
If there is any note, it would be there that she has already been recovered, then obviously it's okay.
Yes.
But she is not before us.
Yes.
Whether she is still alive, how she is there.
Lordship, and moreover, Lordship, petition number, so far concerned petition number 2, Lordship, his name is not mentioned in this affair.
Obviously, but he was arrested in connection.
Lordship, and one thing, Lordship, there is, Lordship, in this case, Lordship is aware the punishment is 7 years. That is 41 notice. I think, Lordship, as per Anish Kumar's judgment, Lordship ought to be given, Lordship, but here that notice has not been complied. So, Lordship, my humble submission.
Victim girl not yet recovered, my lord. and there is no such statement that. And now they are submitting. His submission is that by naming one person Sunil. So how can I at this stage, my lord, come to know that who is Sunil, my lord? Only
Who is
Lordship,
Lordship,
next
CD will reveal the actual proof.
Lordship, my submission, next submission is that, Lordship. As for Anesh Kumar's judgment, Lordship. Lordship, just notice that as because just punishment is.
Girl, we do not know the status of the girl at present.
Lordship.
It is serious.
Lord.
Whether she is still alive or not, or what happened with this girl, we are not in able to position to say anything.
Lordship.
So let us call for the case there. We'll try to give you a big shortly.
Lordship, my submission, my contention is that, Lordship. If the Honorable Supreme Court said, Lordship, when punishment is 7 years, the notice has to be given. So here in my case,
on to 23rd 7, my lord, I can put it. 23 7.
3.
Yes. Today is 2 days.
27, 60 days. Or 24 is 60 days.
No. Well, 23 7, my lord, I can put it.
Highly appreciate.
May I please, my lord? On earlier occasion, there was instructions were sought that whether any case has been registered against us or not.
My lord, case is pending since now. There are many times we have sent messages to the IO, but till now I have not received any information regarding whether any case registered against or not. My lord, your lordship may kindly fix it, my lord, day after tomorrow. If this time, my lord, no report is sent, then my lord, order may be passed.
It on Friday.
Friday. Published. Friday.
Friday.
And my lord,
19th.
Well, otherwise OC has to personally appear because we have sent messages many a times, but till now no.
this most probably the 4th or 5th time the court has given instructions that they should produce.
Our
So
office
that may
also
be
intimated many times, but till now there is no
But
such
the question is that we are going to fix it on day after tomorrow.
Day after tomorrow.
Day after tomorrow, it may not be, but you can contact with the IO.
Yes. Obliged. And on that day, if my lord no report, my lord send, then my lord OC shall personally appear on next statement.
May I please, your lordship? Lordship, the case of the petitioner is the lordship. In the year 2016, lordship, the petitioner had a love relationship with one girl, lordship, victim girl, lordship. The girl eloped with the petitioner, lordship, and thereafter on the next day they got married, lordship. So when the victim girl's father come to know about the marriage, because they don't want to give marriage to him, lordship. After 20 days, the father of the victim girl filed an FIR, lordship. Subsequently, lordship, after marriage, lordship, he gave a birth of a son, lordship, in the year 2017, lordship. And subsequently, lordship, charge sheet has been filed as absconder, lordship. Although, lordship, there was no attempt to reach me, lordship, for investigation, lordship. And thereafter, again, lordship, in the year 2023, also another girl born, lordship, out of them, lordship. So later he come to know about that the charge sheet has been filed and case is pending before the court, lordship. He received later on, lordship, summon, but he could not appear, lordship. That's why, lordship, NBW has been issued, lordship. On lastly, lordship, and on last occasion on 22/5/24, lordship, page 65, and the NBW reissued, lordship. Now, lordship, after getting married and two child has born, lordship, charge sheet has been filed under 366 and 376, lordship. All consensus relation, lordship. So now, lordship, petitioner wants to face the trial, lordship. Only thing is that, lordship, the case is under session triable case, lordship. And the learned magistrate has summoned and NBW issued, lordship. If he appear, lordship, he will be obviously, lordship, after committal only his bail application will be entertained, lordship. That's why, lordship, I am praying, lordship, a similar order, lordship. I have annexed, lordship. Lordship may kindly see, lordship, at page 67, lordship. I am praying for exactly similar situated case, lordship. So I am praying for, lordship, similar relief, lordship. Page 67, Lordship. I have annexed the similar order, Lordship. One of my senior colleague has appeared in that case, Lordship. Well, the minor girl is 9 months, 10 months old, Lordship. So if at this stage he is remanded, Lordship.
So he is the only accused.
Lordship.
He is the only accused.
Only accused, Lordship. Charge though there was section 34 during the FIR, Lordship, registration, but charge sheet filed only against him, Lord. And actually, Lordship, all the regarding Mary's controversy and his father, that's why FIR was filed after 20 days, Lordship. Because his father don't want to be married with this boy, Lordship. Later on, they have consented all. Now, two child is there. I have annexed the birth certificate, Lordship. And last, the girl age is 10 months, Lordship. That's why I am praying for Lordship, humbly, Lordship, this similar order may pass. Otherwise, he will be remanded, Lordship, because the case is session tribal case, Lordship. And this NB will be issued by magistrate learner, Lordship.
Well, in this case, search sheet submitted in the year 2017. He
That's
has
true,
received
Lordship.
2017, and he has received someone in the year 2018. After receipt of someone's ballot in the year 2018, he has filed one adjournment application, and thereafter, till now, he has not appeared before the trial.
Lordship, in the meantime, COVID has also come, Lordship, and I admit that there is fault on my part that I have not appeared before the learner court below, Lordship. Now, Lordship, I am ready to face trial, and Lordship, all the entirety of the case, you Lordship, see, Lordship, the allegations and everything, Lordship. So, considering the factual metrics, Lordship may kindly grant this relief, a similar relief I praying, Lordship. Otherwise, I will not pray for such relief, Lordship. Otherwise, I will appear, Lordship.
Cases of 2016.
16, Lordship.
Charge sheet filed on 2017.
17, Lordship.
And
As absconder, Lordship.
Case is pending only for
Yes.
For fact sheet.
That's true, Lordship, but as a absconder, they have not attempted even, Lordship, because PS police station is different, Lordship, and I married and living happily, Lordship, since then, Lordship. Because later on, this father also and family also come to, two child is also there, Lordship.
Mr.
J. Abbas, Lordship. J. Abbas, Lordship.
And also hard district report. It is submitted to Java that the come from the report below. That it came to put that one is an absconder. However, due to the parents' case, they got married with the victim, and at present they are living happily as a husband and wife, and two children born up. However, mother that suggesting for on the come and this instance the trial court issue and the against him. There is a in this case and the however he is ready and supported. I hope they can and with bad, but in the event of his family, it can be I will support. We will support. Considering the entire facts and circumstances of the case, if they are that was fine. Here as a subject. The present petition with some but then it was responded and that fine. After that's of more than 5 years. Was the subject that being directed to appear in the for file inoffensive. And that despite showing it that the petitioner was served with a sum from his book, but despite receiving some, he did not appear at all. Go on. On 3 occasions, after receiving some, he appeared before the trial court below. True, it is not. That not because it has even after filing of the charge sheet. That according I however considers it something that constitutes as proper to direct a in accordance with law. However, in 10 days of this evidence, we will appear before 10 days with 10 days of this evidence. The NDPS issued against it with the petition shall be they are directed to appear before the learned trial court below until within 10 days, and till then your NBWA will be stayed as suspended. Even if after the direction, if it is your bail petition is not considered, then will see. See now for your conduct, this case is pending for 5-6 years.
That I admitted, Lordship.
Okay.
But if
Appear before the
Lordship, obvious Lordship.
May I please, Your Lordship, that the litigation under 482, my Lord, for quashing of FIR, my Lord. Can we see the FIR, my Lord, translated copy?
For quashing of the FIR?
Yes, ma'am.
It is not a charged case?
No, not yet, my Lord. Petitioner, my Lord, was arrested
Now,
and
see, the case is actually section 4 of the POSCO.
POSCO. My Lord, can you see the FIR complaint filed on 8/3. The incident shows here the FIR on 4/3/2024. After, my Lord, 4-5 days, my Lord. Then, my Lord, can we see the bail order of the petitioner? He enlarged on bail by the special judge Pujai, my Lord, and he has granted bail, my Lord. In the view, my Lord, that no, my Lord, case, my Lord,
No case.
my Lord, can we see case 23? Last portion, my Lord, considering the material on record as well as considering the length of the detention of the accused, I am of the view that the further detention of the accused may not be
Considering
required.
saying he was granted bail.
Yes, my Lord.
Now?
My Lord, can we call for the record, my Lord? Everything will remain.
Just tell us who lost the FIR? FIR
Big victim.
FIR is the pay?
Case, my Lord. 13, my Lord. Complainant Husnara Begum. In her FIR, my Lord, he stated that they had love affairs and he came out from the examination, my Lord. No time is mentioned there, my Lord. And she took by the petitioner and another person by a bike, my Lord, to the Nagaon. It is impossible, my Lord. 45-46 kilometers away, my Lord. He took, and again, my Lord, within short time, he dropped the complainant before her home, my Lord. And again, my Lord, can we see the member of the victim family captured the accused at that time, but the family member of the both accused forcefully took them away. My lord, at that time, no FIR, no FIR, nothing. After 4 days, my lord, they lost this affair. So something is there, my lord, may call for the record, my lord. In the meantime, notice may be issued to the respondent number 2.
Case is still under investigation.
Yes, ma'am.
It should not. You are Mr. Apple.
A.J. Atia, my lord.
A.J. Atia. Issue notice going to the to jurisdiction policy, particularly office of the public prosecutor. Also call for case trial. Okay, we are calling for the case diary and notice is to be issued to the respond number
Respond number 2, ma'am.
Respond number 2. As we are calling for the case diary, what report should be it?
My lord, on 21st of August, ma'am.
30?
21st.
21st of August.
August, ma'am.
21st of August.
Otherwise, well, POSCO case well, registered only in the year March.
This
is not a fit case for even, my lord.
Cannot be. Your submission may be correct. There may be love affairs between some. This can be understood, but in that case is registered under POSCO.
Yeah, 21st August.
21st of August. 21 age.
May I please, Your Lordship? It is that case, my lord, where there was no FIR, my lord. Even then, my lord, the police was calling me, and Lordship, my lord, pleased enough to, my lord, protect me. But I have been told, my lord, that even today, my lord, there is no report from the police station as to whether there is an FIR against me or not, my lord. So let them have some more time, my lord. Till then, my lord, this interim order by which I was protected, that may be extended, my lord.
Okay, you have not received any instruction?
No, my lord. On my lord, 23rd.
23rd of this week, or you can take another 2-3 days more because.
Yes, my lord. Can it be on 30th, my lord? 29? 30.
It's from 30. The hard district he told me. Learned also hard district he did for it is subject to Mr. Kofi that there disciplinary reports that is from the I as to whether any case has been registered against the I have reached him accordingly on 30 July of 2004 and feel that the interim be.
I am deeply aware.
Me, please. Justice has yesterday asked for the.
Yes.
Yes,
have you?
I am giving the report.
Yesterday, did it meet? Half portion of the order করেছো আর আসলে So this is of 11-12.
11-12.
And thereafter 9-2.
Thereafter 9.
9-2 you have already annexed.
Yes.
9-3 you have already annexed.
Yes, annexed. As a annexed imping order, annexure E, page 13.
Okay, actually, we have dictated half yesterday.
Lordship.
But as it was not there, so we are not completing, he is not having it. I'll dispose the paper.
Lordship.
May I please, Your Lordship? Your Lordship, the matter was listed day before yesterday. So, and Lordship was inclined to issue notice and stay the proceedings of the lower court also. But as there were some typographical mistake, so we were directed to bring it into the notice of the court by dint of an additional affidavit, which I have filed on the very same date, Your Lordship.
It was Sandeep Sharma, so this kind of typographical.
Yes, Your Lordship.
Do we have the cause list of day before yesterday it was there?
Yes, Your Lordship.
Day before yesterday's list. Most probably it was on 16.
It was on 15, Your Lordship. On Monday.
On Monday?
Yes, Your Lordship.
So as per it was Kabdam. No, but here it's Kabdam. Not deep. But she thought that it was a mistake of book. So half part of there, I just have out. I can.
It was item number
Today's
25.
On that day, it was item number 10. It is Shabnam, I think, because Shabnam that it would have matter of that day also dictated half of the portion, but subsequently you just that there's just some clerical mistake, the typographical mistake of probably the title, which is not the title.
It was only on the translated copy, Your Lord. The mistakes were.
We pass the order. We dictated the other half portion is there. So we will complete by this. Your additional regarding the filing of the additional affidavit will also brought, and the corrected method will be also there.
Highly obliged, Your Lordship.
I don't know what was the order, but I'll pass the order because
Obliged.
half portion is there.
Obliged, Your
It was not true. What? It has yeah. Doesn't remember. But other petition, which Mr. Kakuti was there, it was I think disposed. It was almost disposed, but here we check and most probably notice may be there. But the stay was there, I think. It was the order of stay was there, but also
My lord, this scan copy will kindly after some time. I don't know. Ma'am.
Otherwise, my lord, 161 is not there, the scan copy. 161 statement is not there in the scan copies. 161.
Is it not there?
Not there.
My lord, if my lord 161 statement is not there, my lord, that Fashion. Then my
161 will be required.
yes.
Maybe on 19, my lord.
Huh?
161 is required.
Well, I will verify my point out to your lord.
Just I have this one here. Most probably he is rightly submitted the 161 is not here.
Not there. Then that needs to be called.
You can go through the report.
Yes.
But not there. But evidence is there. I don't know.
Okay.
PW1, PW2.
Then not required. If my lord evidence is there, my lord, then I will go through it and
Even
point out to your lord.
PW3 is also there.
Yes, after some time, my lord.
Okay. All part, sir.
May it please your lordship.
21, my lord, case diary not received.
On last 3 occasions, your lordship, similar is the condition, and today 95 days almost, your lordship, behind the bar. Let the matter be taken up in the second half. Mr. H.R. Chaudhary, senior advocate, will appear in the matter.
That's under section 22C of the NDPS Act, my lord, 180 days, my lord.
You're saying second half?
Mr. H.R. Chaudhary, senior advocate, will appear in the
While
matter.
CD is, my lord, not available, then CD will be required, my lord.
Correct, your lordship. But on last 3 occasions, your lordship has passed order, but CD is not coming.
It is not. Why Mr. Bottom is there?
My lord, investigation is going on, my lord, only. This is, my lord, 180 days, my lord. No.
It is maybe there, your lordship. There are judicial orders calling for space diary, your lordship. 1 occasion, 2 occasion, it's okay.
21 from Gulabganj, my lord. Yes.
Most probably once CD was received, thereafter
Yes, my lord. Thereafter return back
report was
up
called for, I think.
Yes. For up
That
to,
is the main issue. That's
yes,
why
my lord.
it has not been received.
Initially, my lord,
With
CD
the
received, my
FSL
lord.
report updated was called for.
Yes. For which CD again returned back, my lord.
Card Mr.
So short date may be given, your lordship.
Card Mr. Energy for this and also card Mr. report for and so. It is submitted by Mr. Bottom. This updated case diary is not received. In that context, Mr. Losper submitted that the CD was called for since before occasion, but the IO could not furnish the case diary.
Well, earlier, initially CD received, but he has wrongly submitted that CD not yet received.
Yes. But on basis of the record, it is seen that the earlier case diary was, however, it was returned back asking updated case diary along the issue reminder accordingly, and I will is hereby directed to furnish the case diary along with the on or before next date of listing. If it not keep it with but so just accordingly, let him give some more time. Let him be up in the month of August.
From Gulabganj, my lord, 13/8, my lord. FSL report is also.
13/8.
Last week, your lordship, 30 or 31, your lordship. 2 weeks.
31, my lord, again CD will.
Again, same thing
In
may
the
happen.
many other cases. On 13th of August, my lord, on that day I will get the FSL along with.
So lordship, then that it been 2nd of August. Behind the bar for more than 100 days. 100 and
Then on 8th of August, my lord, 8/8.
80.
8/8.
oblige, lordship.
May please do.
22 scan copy not received, my lord. Can copy of LCR, my lord.
It was called on, my lord, on 18/6/2024, my lord. And the accused, my lord, the petitioner is behind the bar since 28/11/2022. And that too, my lord, on
11, 2020.
2023.
2023.
2023. 28/11/2023. On being summoned by the Direct Session Judge, my lord, he appeared and he was
taken into custody. And till date, my lord, the trial has not yet begun, my lord. The no witnesses has been examined yet.
But as per your instruction, whether charge has already been to him or not yet?
Not yet, my lord.
Charge is not
yet.
Yes, what occurred, but we need case record.
Yes, scan copy of LCR Institute.
On 18/6 it was called for, but even after 1 month, most probably they are not.
Yes, it is.
A reminder may be issued through registry, because registry has called for the scan copy of the.
Yes, any date?
8th of August.
8th of August.
Yes.
Can it be in the last week of July, my lord? We'll try last week of July.
Then 31/8.
31/7.
31/7.
31/7.
Issue reminder. Scan copy of the case not distributed. 30/31.
Yes.
3/1, my lord. Great.
Right, Lordship.
Yes.
439 application, Lordship. FIR is page 13, Lordship. I am not naming the FIR, Lordship. And I am behind the bar for last 44 days, Lordship. And my Lord, only on the basis of the co-accused statement, Lordship, I was arrested, Lordship. Page 13 is the FIR, Lordship. In the FIR, Lordship, nothing has been against me, Lordship. Page 13 is the FIR. It's a long FIR, Lordship.
Yes, what occurred?
Yes, my lord. Initially, my lord, police arrested one Kusum Mir, my lord, on the basis of the my lord, source information. Thereafter, my lord, many other persons were arrested. And thereafter, ultimately, my lord, one Sahara Begum was arrested in this case. And from the statement of the Sahara Begum, my lord, the present accused person, Asadul Ali, was arrested by the, my lord, police, my lord. And, my lord, as per the statement of the Sahara Begum, all these, my lord, contrabands were, my lord, were coming to her, my lord, from the present accused person, my lord. She received, as per his statement, my lord, Sahara Begum received all these, my lord, contrabands from the present petitioner, my lord. Regarding that, my lord, statement, Sahara Begum statement is also available in the case diary, and Asadul also my lord, admitted in his statement. And this is the statement of Sahara Begum, and my lord, statement of the Kusum Mir, who was first arrested by the police, my lord. And thereafter, during investigation after arrest of the my lord Kusum Mir, police arrested many other persons and recovered, my lord. From my person, nothing has been recovered, lord. Yes, my lord, he is the supplier, my lord. He is not required to, my lord, recover from everyone's possession, my lord. কালি কোনচামা ল্যাংকা পিছন লাগছে
The target which kept in India was state responsibility. And it's an application of this submitted the instruction that the present accused petitioner himself he was not be connected in the office. However, he was arrested in connection with this case only on the basis of statement made by the wake person. He did behind words and asked for 4 days and in considering his language and also he made nothing further he submitted and ceased from the person to the present accused petitioner. And I have worked sufficient time for this custody verification. Mr. Bott submitted in this context that the present accused petitioner is a drug dealer and he used to deal with the business of drug and supply the drug to the other person and some of the persons also. From the statement as well as the statement of the other, it reveals that he is a drug supplier who deals with the business of drug and the business of drug, which is part of Assam in Luxembourg. According to Mr. Bott, submitted that not it is to analogy accused to pay. Hearing submitted with very running counsel for the state and have registered with record. And it is seen that the present accused petitioner is been updated by crime and his name has been and he has been enjoyed crime and he used to deal with the business of drugs and supplied the drug even in different parts of Assam, especially in Luxembourg and even in Arunachal Pradesh. Considering the conduct of considering the materials available in his diary and the rest of the find that it is not obvious to allow the accused petitioner to go on bail at the state as the possibility of absconding and hampering and tampering the further investigation also cannot. Your bail petition stands rejected.
44 days lordship, nothing is required for my possession lordship. If I am a supplier, some quota should have been recovered from my possession lordship.
It's I think 29 is also there.
Like. Well, item number 24 may kindly be taken up after some time. I will have to, my lord, verify some facts from the IO because, my lord, here everywhere, my lord, section 21C is there. But, my lord, here seizure list and everywhere, but on the quantity of the, my lord, heroin is not of commercial quantity. So, I will have to, my lord, talk to the IO.
My lord, when other day, my lord, if your lordship correctly remember, my lord, on the other day, when I point out this, my lord, that is why your lordship asked to collect the seizure list. Man, it is not in the court below record. That is your lordship kind enough to call the man. If there is a seizure list, man, if the quantity is, man, it is obviously less than.
He is saying that he was verified.
Verify from the record, not from the IO, my lord. Already it is seized, my lord. Whatever, if it is a commercial, if it is a, my lord, less
Not
than.
on that, he is submitting that there are some contradictory, so he wants to verify the record. We keep it after some time.
Yes,
we are taking the record after some time.
May it please your lord. My lord, in this case, the charge sheet has already been filed, my lord, and the accused is languishing in jail since last 72 days, my lord. I think CD has not been received, but without CD, your honor may consider my case, my lord. The FIR is at page 12, my lord, relevant part.
25 scan copy was called for earlier. Scan copy of LCR and CD, my lord. LCR and CD not district.
It's a stolen, 4 fan was stolen from the school, my lord, and the stolen property has been recovered from the main accused. I am 19 years old, my lord, misguided teenager, my lord. The other 2 accused are aged about 30 and 40 years, my lord. And my lord, the charge sheet, my lord, kindly peruse at page 25. Page 25, my lord, column number 18. Charge 1, 2, 3. I am number 3, my lord, Vishnu Baspur. So he has been charged under section 380, my lord, and the other main accused, Rustam Bahadur Qadi, he has been charged under section 411, that is habitual offender, and the 413 IPC, my lord. Now, my lord, the bail has been rejected by the lower court. The rejection reason may be seen, my lord, at page 29, my lord. The last pair, my lord. As the punishment provided for the alleged offence under section 413 IPC is serious in nature, which may extend up to the life imprisonment. Hence, I am not inclined to allow the bail petition for releasing the accused person, Sahidul Islam, Jugdu Baskar and Rustam Bahadur Qadir at this stage. My lord, I have been charged only under section 380, my lord, and I am only 19 years of age, my lord. If I will languish in the jail, I will be further be misguided, my lord, misguided by the other inmates, my lord. And if I will come out, then I can take proper defense, my lord, because the trial is going to start, my lord. This is the
Where from you're saying that you're 380?
380, my lord, that
Page number 24.
page 25, my lord. It's a part of the charge sheet, my lord. He has been charged under section 380.
What is his name?
His name is Vishnu Bastor, aged about 18 years. Now he has become 19 years. And the other accused person are 30 years and 36 years, my lord. My name is Jugnu Basu, number 2.
Huh?
2, my lord, Jugnu Bastor. 3 is the other one. So he has been charged under section 380, and the main accused who has stolen the 4 fans from the school, my lord, that is Rustam Bahadur Qadi, he has been charged under section 411 and 413 IPC, my lord. And whereas the learned trial court, while rejecting the my bail application, it has wrongly been held that I have been charged under section 413 and it may extend up to life imprisonment.
What was the allegation? What was the theft?
Theft of 4 fan, my lord. That is in fan, my lord. Ceiling fan, my lord, from the
Ceiling
school.
fan.
That FIR is at page
School
12.
premises.
School premises. By the main accused, my lord. I'm languishing in jail. I was arrested on 6/5/2024. Until today, it has become 72 days, my lord. If he will be remaining in the jail, he will further be misguided, my lord, and he may become hardened also. And for taking proper defense in the trial, my lord, he may be granted plea, considering his age.
This water brand.
Otherwise, my lord, from the forwarding report, both the accused persons, my lord, Shahidul Ali and Jugnu Basford, they are habitual offenders of the locality. That is one of the page 15, paragraph number 3. My lord, I will leave it to your lordship. Otherwise, he is also a habitual offender of that locality.
submitted the District Council for that presenting petitioner was and he was a boy of 18 years at the time of his law and presently is a 19 years old. He was being misguided by some person as some of the co-experts are more than 30 years of age. But submitted that the Sunday trial had earlier taken his bail at 6, only considering the fact that the case has been charged under section 430 RPC, which is a serious nature of offense. But from the charge, it is very much evident that the case charged against the present petitioners along with 2 others only under section and not under section 430 of the IPC. Most of the accused individual persons stand by considering length of detention, he may be arrested. Mr. Gordon submitted Mr. Gordon submitted in this regard that the present accused petitioner is also involved in the arrest of the from the forwarding report. It is seen that the present accused petitioner is also a habitual offender, and according to the submission that according to the date of the submission is not weekdays. Next one. Hearing submitted with the case, I have also finished this report and the evidence filed along with the fact that accused is with the persons 6/5/2020 for and statement also said that the case has been charged with the present petition and not under section 411 that 430 of the IPC. Considering the length of detention already undergone by the accused, the tender age of the and other aspects of it, I find it is to allow the accused petitioner to go on bail for suspension. Where is the bail?
CGM Lakhimpur, not Lakhimpur.
Okay, you are done.
Highly obliged.
Yes, so that was the matter, na?
Yes. On the last occasion, I had advised that the money seems to have been paid. I think he only needs to verify whether it's been paid or not.
Yes.
Yes, doctor, I'm confirmed.
It was, in fact, it's on Monday, but...
I was appearing in another court, Lord. That was the issue. Otherwise, I was on that day also present in this court. But I was appearing in another court. That is why I could not.
Yeah, it's okay. So, you have, on the last occasion, you have submitted one online. Like you have submitted.
Just a list to...
Submitted one list like...
Yes, I've given a list to just to say money stands being paid. If your
yes.
doesn't have it, I can give it to you.
One second. Can you give us a friend? Oh, no, it's here. You're submitting that your bail is also granted, na?
Yes, in the Supreme Court, yes. This is based on this settlement itself.
Supreme Court granted bail to another accused, Lordship. Here the husband is here. The wife is
only based on this settlement. That's all I was saying.
So have you checked this one?
Lord, I am confirming that the terms of that agreement has already been complied.
Terms of the agreement is complied. already outstanding. I mean, it was around
11.25
11.25.
stands paid now.
So, this matter was, in fact, pending. So, Mr. Sachin Prabhakar Adhikari was on interim bail.
Yes. And he had to complete this term of the agreement, which is now completed.
In fact, your lordship rejected his bail application. But subsequently, when this agreement was signed, your lordship
it
was
was earlier rejected.
Yes.
And subsequently, another application was filed on the compromise basis.
Based on the compromise.
On based of compromise, it was interim was there.
Yes.
Till disposal of.
Grateful.
So at present, the bail, interim bail, may be made absolute.
Absolutely.
Is there any other subject?
subject to but
Yes, but
while the custody, still custody may not be necessary in
he was earlier was on interim bail by the order dated 20/02/2024, subject to payment of all these things. So now it has been complied with. So his bail may be made absolute. So custodial detention or custodial investigation may not be necessary.
to the investigating authority as and when required for my
Oh yes, obviously those things will be there. Those things. If his presence is required by or his cooperation is needed, then he will have it. Otherwise, you can dispose of it.
Great.
obliged.
Order.
Extremely good.
Yes. Huh?
May I please, Your Lordship?
Here, PP will appear or NCB?
NCB. NCB, Lordship.
We'll just try to inform the NCB.
Yes, sir.
That's
Yes, sir.
yes, right.
Lordship, wheelchair was called for. Lordship, I was linguishing.
LCR not yet received money.
Notice was issued to the respondent too, Lordship.
Earlier only notice was issued. LCR
LCR to yes.
The LCR was also called for, I think.
Yes. Scan copy of LCR not yet
Scan
received.
copy was called for, notice to issue. So have you taken steps?
Yes,
issue
Lordship.
notice? But thereafter it is no note as to whether the papers served or not. Can the registry make an inquiry regarding the service of notice?
No.
There is no note from the registry.
No, madam, from my office, I will inquire from the IO, madam. Because
If it is supposed served and all, then we can appoint anyone or it can be proceeded.
yes,
But today, most probably, this scan copy is also not received.
yes, I will confirm from the IO, madam, whether notice served.
Otherwise, as per your instruction, case is at the stage of evidence or
Yes, Lordship.
at the evidence.
I am languishing in jail, Lordship, from last 298 days.
We have to go through because it's a case of section 6, in fact.
Yes.
Section 6 POCSO, that is the main problem.
The petitioner is also teenage. He is 19 years old. A short that may be fixed, Lordship.
Hard discharge as to regarding counsel for the petition and also hard discharge report regarding the opinion. correspondence. From the office note dated 15/7/2024, it is seen that the scan completely is not yet received by the PHP. Issue reminder. Those from PHP will get it. Further, it's seen that the no service notice, service report is received for the responder number 2. Though from the office note dated 29/6/2024, it is seen this case has already been taken for issuing notice to the responder. In that context, Mr. Bott submitted that he may make an inquiry with regards to service of notice to the responder number 2. The matter be accordingly received. Very short date will serve the purpose.
On 2nd of August, 2/8.
2nd of August.
2nd.
As per last order, Your Lordship, additional affidavit has been filed to bring in record the search sheet number and the particulars of the case where it was pending. Page 20, Your Lordship, point 3, I have mentioned the case number
You
as
have
well.
filed already filed.
Yes, already filed. I have filed it yesterday. Order was passed day before yesterday.
You filed it yesterday only.
Yes, because the order was passed day before yesterday.
We have not received it.
Lordship can take a copy.
And I do, my lord.
Copy is there, other
Order may be passed. Because that is, my lord, not till now not a part of the record. So without getting that record, my lord, how?
Lordship may fix it too.
we are trying to see if it is before 1 we reach, then we'll take
Yes,
up.
yes.
On otherwise,
Obliged.
Come on.
May I please your lordship?
yes.
My prayer is that to adjourn the matter of the day, ma'am.
CBS not received, my lord.
Did you receive?
Not received.
Are you on internet?
Yes, ma'am.
Internet.
It did not receive. And internet because instead of this.
7th of August.
7th of August. We are listing it on 7th of August, or interim will be continued till next.
Much obliged, your lordship.
28th of Samala, city not.
28 also we are not receiving.
28 and 29 same.
28,
Same, my lord. City not.
In 29 also you are on internet?
Yes, sir.
Goista.
Both
It will
are
be considered
5th of August.
5th of August. Both the matters that order of 5th of August.
All right.
Just now we have received the injury after some time. Because just now.
Typing matters are lost.
Or in another day, just now we have got the city transfer.
Better to take in another because timing matters are lots of timing matters are there. Are you on interim? Are you on interim?
Not in. Small city, my lord, will go tomorrow. Today itself.
Today itself. Okay, after
Small
time.
city.
May it please your lordship. Your lordship, I am appearing on behalf of Mr. S.D. Pastor. My senior is legs in court number 14. Kindly pass for the matter for timing.
What I am on
here in this case, sir, I am for the informant, and I have filed an IA regarding a false document that has been annexed with this particular anticipatory bail application, and for that purpose, I have made that application under section 340 of this CRPC for initiating an inquiry so as to registration of a case. So that IA is not been part of the record. So may I pray for a date wherein this IA can be brought on record, sir? We have already filed it on day before yesterday.
Day before?
Copy paise na? Interim, sir. They are on interim.
The same lordship, it needs to be updated, lordship, because if they are on interim lordship, the statement is not in the case date. So I may be allowed to statement of the petitioner's lordship. They are on interim lordship, but their statement is not in the case date. So I may
Have
be
you
allowed
appeared before the IO for recording of the statement?
Your Honor.
Don't have any.
IA number 2 sir.
You are Mr.
A Islam.
H. Not.
A Islam.
A. Islam. Heard Mr. A. Islam, that was deputy on behalf of Mr. S. For the petitioner, and also heard Mr. Council appearing on behalf of the informant, and Mr. P. Sharma for the respondent, state respondent. Will be Sharma for the informant. They have already filed I. I is numbered or?
It's not been numbered, my lord. It's been filed on 15/7. In due course, it will be numbered.
As I as there's some documents.
False.
False document.
Not false. False document.
False document. Some false document has been filed in connection with different details. Accordingly, the subject some time that the I has to be tagged with the present case record. In the meantime, Mr. Sharma did not also submit that after the case diary is required as a statement of the petitioner is not in the case diary. So, the petitioner interim period. Consequently, entered submission made by London Council for the respondents. Let the matter be listed.
On
which time you need?
Let it be in August. Second week of August.
In the month of August?
August 2nd?
You want to return it back? Or?
Yes. We'll like to send it back. Let it be 6th of August.
6th of August.
6th of August. Let the matter be listed on 6th of August. Otherwise, you are having this CD. It is to be returned.
Yes.
CD be returned back. Calling updated case diary. 6th of August. Interim. You are on interim.
Interim.
Interim be continued till next day.
Till the next date, my lord.
Yes.
Obliged, my lord. I go.
32 lordship charge sheet has been submitted.
Sir.
It is already charged sheeted.
Yes, sir.
My lord, I am praying for 15 days time to appear before the learned.
No, anyway, are you on interim?
No.
You are not on interim. If you are not on interim in that case, so we cannot.
In the meantime, I will appear.
No, you appear. It is up to your liberty. But if you are in the interim, we could have extended the interim. But if you are not in interim, then it will be difficult. Because now we don't have anything before us to grant you any interim also.
Sure.
So you are Mr.
Anuddin.
Anuddin. Heard
Yep.
Mr. Anuddin, the London Council for the Petitioner. Also heard Mr. P. Sharma, the London Edition PP, appearing on behalf of the respondent. It is submitted by Mr. Sharma that case has already been charged by CS number
57/24.
By CS number 57.
57/24. Dated 29/6/24.
29.
29/6.
29/2020. And accordingly, he submitted that in view of filing of the charge, the petitioner we appear before the learning trial would be that appropriate application for. Considering the submitted that we done it for the learned education and also considering the fact that the case has already been charged, comma, when we have a that is quite an appropriate application for pay. appropriate application for pay 14 and 12, which may be considered in accordance. Let's see, we appear to put it out.
May it please your Lordship. Lordship, this is a 438 bail application, Lordship, FIR on page 13, Lordship. Here I am for the accused number 1, Lordship, Kabir Ali, Lordship. Case was registered under Lordship, Provision of Child Marriage Act, Lordship, 9, 10 and 11, Lordship. So for allegation, that is 9 against this petitioner, Lordship. Now, Lordship, as per the Lordship, Aadhaar card, the date of birth of this petition, Lordship, victim, Lordship, here is 16 years, Lordship, 2006, and the date of birth as per Aadhaar of this petitioner is Lordship 2004, Lordship. Just Lordship 18 and 20 years. Now, Lordship, the informant is the Lordship, not the parents, Lordship. The FIR, Lordship, will find on page 13, Lordship. May I read, Lordship? It is respectfully submitted that I am a VDP member almost 8 to 9 months ago. Jamal Ali's minor daughter, Almina Khatun, got married with the accused number 1 in connivance with the accused number 2 and 3 in the house of Jamal Ali of number 1, Borbala village. The wedding was held secretly by the accused person. After the marriage, the girl became pregnant, although the accused person secretly aborted her pregnancy. But the section, Lordship, IPC section is not there, Lordship. So far, the Lordship, abortion of the pregnancy is concerned, Lordship. Lordship, kindly come to the page 18, Lordship. Here, Lordship, impression, Lordship, on the bottom column, Lordship. She is 32 weeks pregnant, Lordship. It's a diagnosis center report, Lordship, that too on 18/4/2024, Lordship. Yesterday, Lordship, the victim's age is also given, Lordship, 18 years, Lordship. Since, Lordship, they have Lordship, a relation, Lordship, ultimately, Lordship, enter into marriage, Lordship. And so far, this petitioner is concerned, Lordship, he was aware this that girl is, Lordship, 18 years, Lordship.
Jamal Ali.
Jamal Ali is,
Jamal Ali is the father.
Father of that victim, Lordship.
Nine, 10, 11.
Also, age proof regarding Lordship, there is only this Aadhaar card, Lordship. First school certificate, Lordship, we could not place, Lordship. Regarding age proof of that victim girl, Lordship. Even though, Lordship, they are in a relation, Lordship, that's why the boy is not much elder, Lordship, only 2 years difference between them two.
Nothing.
313 IPC was not added, Lordship. So for abortion part is there, Lordship.
Okay, may I submit it? Here, Lordship, the as per the seizure list, her school certificate was seized, Lordship. Her date of birth, according to the school certificate, is 1/1/2011. So at the time of occurrence, she was 13 years. 13 years. Now, Lordship, there was no previous relationship as per her statement, Lordship. Her statement has been recorded on the 164. She has stated that she was forcefully abducted, forcefully married. And now, Lordship, as per the medical report of 18/4/2024, she was pregnant at 32 weeks and 5 days, as on 18/4/24. So apparently she is a minor. And one more aspect, Lordship, on the prayer of the IO, Lordship, 366 of IPC and 6 and 17 of POCSO has been added. Furthermore, Lordship, the family members as well as the petitioner approached the court below, Lordship, for grant of bail. The family members were granted bail, but his bail was rejected, Lordship, after perusal of the case. So if Lordship kindly goes through the 164 statement, what she has stated, Lordship, she was forcefully abducted and forcefully married, Lordship. 13 years of age, Lordship, a minor girl, Lordship.
One more submission, Lordship, regarding age, Lordship, is it the first school certificate or not? That has to be taken into consideration because the age has to be determined in the Lordship POCSO case regarding the victim, Lordship. That has to be followed under Juvenile Justice Act, Lordship. Whether
we are not in that stage now.
Yes, Lordship, whether that was the first school certificate or not, that has to be taken into consideration. Yes, Lord.
In the course of trial.
We are not court of trial.
So for documents supplied to me, Lordship, the Aadhaar card say it's a 2004. Date of birth is given, Lordship, 1/1/2006.
And after marriage also, Lordship, she was subjected to cruelty, Lordship. That is also in the 164 statement.
That apart, Lordship, this informant and that Lordship, this victim and the petitioner hail from the same village, Lordship. So there is no chance of Lordship absconding, Lordship, if Lordship has protected this petitioner, Lordship. They will face the consequence, Lordship, after Lordship charge sheet, Lordship. Till date, Lordship.
As per Supreme Court judgment, Lordship, the testimony of the victim prevails over everything else, Lordship. If she has implicated, Lordship, nothing else matters.
Now, Lordship, as per Lordship POCSO Act, Lordship, the victim has to be examined, Lordship, within, as per 164 capital A of CRPC, within 24 hours of the record, register of the FIR, Lordship. Whether that has been done or not, Lordship.
parties to each of the that this petition and they got married. He got married. Him as they had Lavia more so as per the other country, the thing is about exceeded 19 years of age and the different time of her marriage. Further, there is no further the identity register contribution to the country. I think though the of abortion of the child is also brought. He further submitted that both the accused and the victim are living happily, residing happily as a husband and wife, and hence, and a wife, and there is no kind of conflict which they will have for the eye of the husband is appropriate. According to the subject, it is a biggest very privilege of bearded spirit can be granted. And additional BP submitted with regard that implementing measures in the case diary and especially the statement of the recorded as per her was abducted and with one article and had sexual intercourse and for which got pregnant. He further submitted that during the investigation, the IO also collected the school certificate of the victim girl, and as per the school certificate, the date of birth of the victim is 1/1/2011, and thus at the relevant time of her marriage, she was 1 year of age. He further submitted that in this case, as per on the considered case, considering the prayer made by the IO, the learned court below had also added section 366 IPC along with section 6 of the 17 of the law. Accordingly, it is objection that it is not at all of the case to allow the petitioner to grant the by hearing the submission made by the non-responsive officers, I have also and say that the school certificate during the time of investigation. However, it is not record in record as to whether that the school certificate was obtained by the was the date of I has recorded, which has recorded date of birth of the victim at the time of the murder. But these are the matters to be decided during the trial of the case, and the actual age of the victim also may be determined during the trial of the case. But considering the available methods in this record, the statement of the victim, it is, I find, this court is also not at all in case that
Obliged,
Just
Lordship.
as rejected.
Obliged.
Rejected.
This is Lordship second bail application. Earlier it was rejected by your Lordship.
An application call for the petition. Have you received the case guide?
Yes.
Can it be listed or after 1 week?
After 1 week.
1 week, this is next week.
Next week Lordship then we will get.
25 7.
Yes.
25 7 or
Yes.
25 7. This not till then CDB.
Make resolution. No, this is a 438 application, my lord. The FIR is at page 17. 17. The sum and substance of the FIR is that the petitioner number 1 and number 2, who are the husband and wife, they had siphoned the money of the informant's deceased husband from his account. May I read the FIR, my lord? With due respect, I beg to state that from the last 5 years, me and my family members know the accused persons and we are family friends. On 7/5/2021, my husband passed away. The accused persons came to my house to pay their condolences, and on the death of my husband, the accused persons helped me with respect to obtaining the death certificate of my late husband, money transfer from my husband account to my account, and also helped me to transfer my husband's group insurance money to my bank account. Sir, 3 months after the death of my husband, the said accused persons came to my house. At that time, I told the accused persons that I want to build a house at Birikuchi, which is the property of my husband, and for that I sought help from the accused persons to help me with financial assistance to the tune of 15 lakhs. Then they told me that they will manage to get me a personal loan in my name from my Canara bank account of Bonda branch. For that reason, they took my Canara bank ATM card, passbook, Aadhaar card, the SIM card of my husband's phone number, being number so-and-so, which is linked to my Canara bank, 2 copies of passport size photograph, and 4 copies of signed blank papers. After 1 week, they came to my house and informed me that I am not a servicewoman, so the bank loan cannot be sanctioned. At that time, I asked to hand over me my Canara bank ATM, passbook, Aadhaar card, the SIM card of my husband's phone number, being number so-and-so, which is linked to my Canara bank so-and-so, 2 copies of my passport size photograph, and 4 copies of signed blank papers, but they denied me to hand over me the said documents, and they said that they will manage the amount of rupees 15 lakhs only from their society. For that purpose, they need all my documents. But they told me that I had to deposit as security amount of rupees 5 lakhs only in favor of the society to avail the loan. And for that purpose, they took 4 checks amounting to 4 lakh 12,200 odd something only, and balance amount was paid through Google Pay. On April 22, I made the complete payment of rupees 5 lakhs. Sir, after 2 months, I did not get any information from them, and I made a call and asked them about the society loan. They told me to wait for some more time and the loan will be sanctioned within a week or 2, but to no avail. After that, on 2nd February 2024, I went to Canara Bank and I came to know they transferred an amount of rupees 7,60,000 only to their account through Google Pay by using my husband's SIM card number so-and-so. Sir, after that, I asked them about the aforesaid issue, to which they told me they will return back my money of rupees 12,60,000 only very soon. However, 2 months have gone and they are not meeting me even after my efforts to meet them. They receive my phone calls but threatens to kill me. Therefore, this is the sum and substance of the FIR. Now, my lord, it has been registered under 420, 120B, 406, 506, my lord. Now, my lord, the thing is that as far as my instruction goes, they are family friends, and they, both the husband and wife, the accused, named accused, they were actually helping the informant to take out her money. And my lord, presuming this be true for a while, Ultimately, these are all documentary evidence, matter of documents, which we cannot hamper or temper. And I guess so, the investigating officer must have seized everything, So I humbly pray that we be allowed to go on bail, and if consequence be, charge sheet will be filed, and we'll face the trial, And petitioner number 2, who happens to be a government servant, she is on interim bail. Let the public prosecutor proceed.
Number 2 is
On it.
Number 2, petition number 2, being the lady and the government servant, on the taken interim order was granted, and she appeared, but interrogation was made by the IO. Now, the fact is that the informant believe on good faith, hand over the bank details, even the SIM card also, husband's SIM card. Now, to get the loan, that details in the FIR in details, they took 7,60,000 from the husband's account. When she inquired in the bank, even they took earlier 5 lakhs for granting loan from their society. So, as he is not a serviceman, he will not get the loan from the bank. So, he gave 5 lakhs in the name of the society, but they didn't give any 15 lakhs rupees loan. Again, they transferred 7,60,000 out of 7,75,000 from the bank account of the deceased husband. Now, all details, yes, police seized everything from the bank and all this. But I was also give a bail objection regarding the husband. So his custodial interrogation is necessary because the huge amount, the whole amount of the lady has been taken by this persons and they, if enlarged on bail, they may detain the lady also. And only the wife, yes, he appeared after getting the interview. So I have strong objection regarding the husband. Petitioner number 1.
Out of all the alleged transactions, we have paid back an amount of rupees 1 lakh once and 15,600. It must have been reflected in the case diary. What I'm trying to submit is, presuming for a while that this FIR is true or not, there was a miscommunication or some misunderstanding between the informant and the accused persons. All that I'm praying is, let us go on bail, let us be enlarged on bail, and whatever the misunderstandings, we'll try to settle it.
Till now, as per you, how much you have paid?
We have, as per my instructions, we have repaid an amount of rupees 1,15,600 rupees.
Out of 12,60,000.
And it can be any day recovered. And as my learned friend, the public prosecutor already submitted, everything has been seized. What else remains? Why my custody is required? If everything has been seized, and a human can lie, a document will not never lie. If everything is seized, charge sheet will be filed, I'll face the trial. Why my custodial didn't is required?
As per the objection of the IO, is in active stage of investigation, and the
So
case number 1 may threaten the victim.
If that be, any day my bail can be cancelled under 432, 439 too.
Only because of that, I have objection regarding the husband.
And regarding
already appeared.
And regarding the threatening, only one line. And when she calls, we threaten. That is why 506. If that be so, if I am enlarged on bail, if that be so, I try to threaten. Any day the prosecution can come for my cancellation, or the informant can come.
what is your plea? You have, what is your stand?
My lord, my stand is, yes, we actually took the money on her instance. We took out the money on her instance. She had given us. She had given us the PIN, she had given us the GP. And there is some misunderstanding between us and the informant. Let us sit, we'll solve the matter. Whatever she gets, we'll return it.
Some amount of money was withdrawn from the account of the husband of the informant, but instructed and he husband gave them the bank details, the ATM card and SIM card. He entered dispute arose only such, but if any amount is withdrawn from the account of the husband of the informant, the petitioners are ready and willing to return this, and during the pendency of this case, they have already returned 1,50,600 to the informant. Further, he submitted that the acted of and hampering or tempering the evidence does not add. The petitioner that the cooperative island for they are done. In that context, Mr. Parashar Lanade petitioner number 2, that the wife of petitioner number 1 has already granted which he entered and accordingly appeared to be added, and her statement is also recorded by the but from the evidence available in the case record, case diary, it is seen that they took they collected around 7,60,000. They withdrawn around 7,60,000 from the account of the husband of the informant. In the same time, they have also insisted the informant to give them 5 lakh if pretext that they will take a loan from the bank. Further submitted that as per the note of the IO, the accused petitioner number 1 is threatening the informant, and there is a probability of hampering or tempering the witness, especially the informant, if he is enlarged with bail. If he is granted with bail. Next question. During the submission made by the facts and circumstances if the service available with that this court that the custody petition is not required in this case. It is already open at this case, and the interim pleaded faith granted to the accused petitioner number 2, namely Mrs. Anamika Katriya, is thereby made absent. Same granted faith to 25 citizens, thereby made absent. Further, the accused petitioner number 1 is thereby granted which the interim pleaded faith will that they make with the direction to appear before the IO and cooperate immediately. Accordingly, provided to Karika Chandriwa, updated his diary for and number 2 we made absolute, and number 1 we are granting interim so that you can appear and cooperate with the IO. For number 1 we are granting interim so that you can appear before the IO and cooperate. But we are listing it, and number 2 it is already made absolute.
9th of August.
Thanks. You are calling that updated case.
Yes, ma'am.
You appear before the IO within 7 days. Cooperate.
My lord. Deeply.
Oh, I.
Other matters report have been for other 37, 58.
My lord, 58 is the IA. We have filed, yes.
58 is the I.
Yes, for modification of the order passed by your lordship on 7/6/2024.
Oh, achha. So why 37 is for now?
37 is fixed because it was fixed while granting the interim. It is fixed.
Main camera, he has interim granted, but he, due to illness, he has not appeared.
You could not appear.
Yes.
So you want to extend this time?
And I am seeking modification of that direction for appearance because, my lord, he is a heart patient, he has a bypass surgery, and as your lordship knows, on 1/7/2024, he had a checkup and his potassium and sodiums are very low, so he is disoriented, my lord. I have annexed the documents in the IA, my lord. And accordingly, I prayed that the condition for appearing, recording my statement before the IA may be modified. Because
Now I will come to your residence or how?
or VC, my lord.
Oh, acha, you can approach the proper forum. I think proper. I mean, it was passed by Justice K.D. Chaudhary.
Yes, madam.
So
The
we
interim
will list it tomorrow for them.
Well,
Both the matters will list for 37 and 58. We tomorrow is 18th. 18th, so before the airport date. Okay.
Deeply obliged.
May please load 438.
Itu mata ko pahila te dik. Last year he's already been extra karo mat said.
Lordship, this matter may be listed before the appropriate bench. Lordship.
Oh,
Here,
item number
54. Lordship. Earlier bail was rejected by the Honorable Justice Robin Fukan.
Oh, earlier bail was rejected by
2022.
Lordship.
Actually, also this
earlier bail was rejected by Justice Fukan.
Honorable
Robin
Justice.
Fukan.
Actually, also that has been not informed me by the accused also. That I was unaware that earlier the bail application has been rejected.
Oh.
Accused has not
So in
informed
the
me.
present petition you have not mentioned all these things.
Yes, yes,
Oh,
Lordship. He has not informed me, Lordship. That is why
You can
I was unaware.
we will fix it before the appropriate bench.
Yes,
There you can file in your additional one
yes.
because you may not aware of. So
yes, yes, Lordship.
we are on 54. 54 same of
B number to
so listing tomorrow will be convenient for you or it can be listed up
Next,
day after tomorrow.
next week, Lordship. Next week, Lordship. Next week.
Next week any date. 22. This
Must-
for appropriate bench of bench.
B number. B number to
Deeply obliged.
May please, Lordship. 438 bill application. FIR is page 20, my lord.
Huh?
FIR is at page 20. My
FI is at page 20.
20. My address is shown is here Longhi Gaon. Accused number 1. Longhood. Accused number 1. Lordship. Page 20.
So you are
Accused number 1.
accused number 1.
1. My
How-
address of village is Longhit Gaon. Here. But actually I belong to the at page number 36. I submit here identity card of election identity card. I belong to Mukhim Inghi Gaon. Page 36. Mukhim Inghi Gaon.
Now you belong to Mukhi.
Inghi Gaon. Due to address problem.
Accused number, right? Accused number 1. As per address in the FIR. Long down. Accused number 20%. Long down. But as per, but he is the resident of. But he is actually the resident of. He is resident of Mon.
Mukhim Inghi Gaon. Mukhim Inghi Gaon.
Page 35, Lordship will find the present address.
36, Lordship.
Mukhin
35. With voter ID card, Lordship will find top portion. Look.
Top portion, right.
Address, village, town, Mukim Inghi Gaon.
যাতে পেজ নাম্বার 36 দেখো তাতে অ্যাড্রেস গুলি এটা আছে হ্যাঁ হাউ মুকিম MUKHIM মুকিম ইংহি গাঁও INGHI ইংহি গাঁও ইংহি গাঁও পেজ নাম্বার 36 yes
Then my lord, someone was issued to wrong address, my lord, and I have never received the summon. And learned code below, my lord, page number 35, learned code below passed against me NBW NPA. And this type of related to the same FIR, accused number 3 and 7. And due to address problem, they learned code below filed against them NBW NPA. And they appeared before this honorable court, my lord, at page number 38. Page 38. Due to address problem, they appear before this honorable court, and this similar order, my lord, they can learned court. Page 38. Same FIR, accused number 3 and 7. Due to address.
accused number
Similar
3
order.
and 7
Similar order, maybe, my lord, maybe.
Viren Bay and Mongol Bay.
Mangal Bay. Accused number 3 and 7.
They are also resident of Muking Lamp.
No, they belong to other village.
Other village.
Other village. Address problem. They have also address problem, my lord. Wrong address has been written in FIR. And they belong to other village. Similar matter, my lord.
Now your PNA and NBW is sent to the proper address.
Proper address, my lord. No, wrong address, this time wrong address they have issued NBW and PA. And by reliable source, I know about this order, my lord. And I want to appear before this learned court below, my lord. Similar order, may
Out of what is from retirement sources came about so LBW and DNA in the proper address or slash present address of the present page. Mr. Sharma, same kind of thing was there.
Yes, sir.
Similar order was passed by earlier.
Let him appear and prepare a bail application. Only my objection may be recorded, Lordship, as it is recorded in page number 39, Lordship. Paragraph number 6.
39.
Yes, Lordship. Lordship's order, Lordship, paragraph 6. Because apparently, Lordship, after the incident, they left the village. So, no.
After the incident,
Yes.
one objection is that submitting that the accused petitioners left the buildings only after the NDPS. Otherwise, it is like same order at page 37 minutes 30. So, Khali, there will be address submission under this thing, observation. Okay. Number 31. This was 38.
May I please, Lordship? Lordship, item number 54, Lordship. Lordship, I may be allowed to withdraw this bail application, Lordship. With liberty to file fresh bail application, Lordship. Because, Lordship, I have not mentioned in my bail application that earlier that has been rejected and that has been informed by the accused also, Lordship. So I may be allowed to withdraw this bail application, Lordship. The liberty to file fresh, Lordship.
54 earlier it was listed for appropriate time precedent or 27. Now prayer made by the Mr. the withdraw as per instruction. Okay, it will be disposed of.
Obliged, Lordship.
That's okay.
Obliged.
May it please your Lordship. Page 9 is the FIR, my lord. In the FIR, my lord, there is no whisper against me, my lord. Page 9 is the FIR. I am Abul Kalam, my lord. In the FIR, my name is nowhere, my lord. My lord, one son, my lord, he has my lord, made a secret information to the police that his father possesses one handmade pistol and one air gun, my lord, broken air gun. That is the allegation. But different person, my lord. And I know them, my lord. This father is my friend, my lord. That's why police has called me. But this is the, but as per the allegation, there is not even a single whisper against me. The son has informed the police that his father has possesses one air gun and one broken hand pistol, Lordship. That is the allegation. A different.
This is FIR is lodged by a son against
No,
his
son,
father.
my lord. Page 9 is the FIR, my lord.
Against his father.
No, he has, my lord, informed the police against his father, my lord.
That is understood. Son lodged the FIR against his father.
Actually, written FIR lodged by the SI of the outpost to the Samaguri PS.
On the information
No,
received from his son.
yes.
Son.
Son. I have gone through the case diary. There are conflict between the father and son, and because of that, the son informed the outpost, and this is the Doni Pigu is the SI of the outpost. He made the formal FIR to the OC of the Samaguri PS. Accordingly, case started. Arms act is there. But where is the apprehension? His name is nowhere in the FIR.
I am the friend of the father, my lord. Police has called me twice, my lord, but I am a friend, my lord. That is my apprehension. There is, I am
Otherwise, nothing in the case diary. His name is not there. Son is Sanidul Jamal.
Police
Father
has
is
summoned me, my lord. I will appear, my lord, if there is something, my lord.
Otherwise, where is the apprehension? I don't know.
Apprehension, where is your
Police has summoned me, my lord. Police has called me, my lord.
No,
any notice?
Any someone is
No. Police has called me, my lord, over phone, my lord. My lord, twice, my lord, before Eid also, my lord. So, my lord, Eid also, I was running from pillar to post, my lord, because of apprehension, because it's arms act case, my lord. But the FIR, there is nothing, my lord. This is the apprehension.
And there is no note of the, I have considered note of the eye also. Nowhere, in the note of the eye also, nowhere his name is there. So
The
how
police came in search of me also to my
no
house
notice
also.
issued, where is the apprehension, my lord?
Because my son, that man, I am the friend of the father, my lord.
It is handmade pistol and airgun recovered from the almirah of the father. Police came, recovered from the almirah of the father, and informed by the son. He is a friend, nowhere in the city, no apprehension.
Police may call him to get some information.
Mama, that's a village people, they are afraid.
To get some information from you, police may call.
Yes, I will appear.
Not the named accused, you are not related with the matter.
So, my lord, there is but the village people, they are afraid, my lord.
If no apprehension, how
we can pass the order? Is there any kind of thing was there that there may be an
No,
apprehension?
lordship may give that observation, lord.
Observation will pass.
There is nothing, no apprehension. So, my pre-arrest bail does not.
Heard Mr. SM Abdullah is responsible for ticket, and also heard Mr. Parash Kilani registered DP appearing on behalf of the it is submitted by Mr. Abdullah that he is known in the office, and but police is searching for him and calling him over telephone as only for the reason that he is the friend of the
Main accused, man.
Friend of the accused. Son brought the
So, Sarifuddin, friend of Sarifuddin.
Friend of one Sarifuddin with the accused of this.
Who was arrested in connection with this case.
And who was arrested in connection with this case.
Equivalent.
He submitted give some protection and according to granted with the privilege of he was submitted that the dispute arose between the father and son, and after we acknowledged the son of the prime accused informed in investigation regarding the possession of arms by his father, and on the basis of which the FIR was lodged by the police officer. But there is no whisper at all in the diary in regards to involvement of the present, nor there is any note I that to have any apprehension of the arrested in connection with this case. And accordingly, Mr. Parashar is not a it's to extend the privilege of witness where there is no apprehension at all. There is no ground of any apprehension of for the present accused petitioner on being arrested in connection with this case. Next, madam, hearing the submission made by the non-responsible and also considering the materials available in the case that it is seen that ground for apprehension of arrest in connection with this case for the present accused petitioner. Accordingly, I do not find any reason to pass any order on interim pre-arrest bail against the interim not the pre-arrest bail present petitioner at this stage. At this stage, I have made at this stage. So that subsequently, if any matter is there, you may approach it. At present, there is cannot be any reason to grant one.
Lordship. Oblige, your lordship.
May this lordship. So kindly take up at 2 p.m. lordship this morning.
Huh?
At 2 p.m. lordship kindly fixed.
2 p.m. May be difficulty. Who is going to at 2 p.m.?
Lordship.
No, one LR Mojumdar is same is one LR Mojumdar is there.
Is it Ahmed will appear lordship?
Is that Ahmed?
Is it Ahmed?
Because LR Mojumdar is going to be out of jail. In one case, that prayer was made. 2 p.m. to I cannot say because lots of matter have been fixed at 2 p.m.
Kindly fix at 2 p.m.
Otherwise, we have received the case diary for us.
My lord.
Mr. Ajit Ahmed is on leg lordship. He's on leg lordship. Ajit Ahmed is
I
on.
understand, yes. Ajit Ahmed. Okay, we'll try. One I not ready one. No. Okay. Professor was busy otherwise, I have seen. That
Yeah,
gone through it.
So yes, my lord, I have gone through the Caesar list and your lordship may kindly peruse, my lord. Yes, in this case, my lord, from the case diary, my lord, something, my lord, your lordship may kindly peruse Caesar list and photograph.
On the first day when moved this petition, my lord, since it is wrong section has been inserted, my lord.
Something disturbing reflects from the case diary and photographs, my lord. Otherwise, my lord, total weight from the Caesar list, my lord, 3.08 gram. With my lord weighting all these, my lord, 7 packets. Then your lordship.
There are description of 7 packets and the without scope cases the weight is there.
Yes. Then
so if you calculate the weight in that case also it won't come
less than minor.
Yes. Your lordship may kindly peruse the photographs, my lord, from in the CD, my lord. Can it be said that this is, my lord, 3.08 gram, my lord? Total 6 kg, my lord. So how, my lord, that discrepancy occurs in the Caesar list and, my lord, measurement? So this matter needs to be inquired to the SP Bongaigaon.
and that for the packets which were shown in the photographs.
Yes.
It cannot be considered
Yes,
as
yes,
0.3 or 0.45
yes,
grams.
yes. Otherwise, in the, my lord, from the Caesar list, total weight is 3.08 grams.
No, my lord, what I am submitting, my lord, of course, what are the matters in the set, my lord? FIR is 0.00334 grams. Caesar is also same, my lord, less than quantity, my lord. I am in the, today is the 90 days, my lord. Maybe, my lord, some photographs, whose photographs, how it is, and
Well, I am not
into
questioning about the bail. I will leave it to your lordship.
my lord.
My
So
lord,
far,
from the
bail
case
is
diary, my lord,
concerned, my lord, it
something
is not a
disturbing,
case that I have given acquittal, my lord. 90 days behind the bar, my lord, our High Court judgment is there. It's under the, my lord, kindly see. My lord, only bail, my lord, it is not the giving me bail at any condition, my lord, your lordship, my lord. It is not that, my lord, I am getting acquittal, my lord. My lord, I have to be, even then, my lord, less than small quantity, my lord, or small quantity, I have to face the trial, my lord, definitely. So,
Small quantity is 5.
Small quantity is 5 gram.
It is
And
less
commercial is
than
250 gram. My lord.
250 gram. My lord, assuming, my lord,
But, my lord, why this
I have to face.
discrepancy in measurement and, my lord, Caesar list?
My
So, my lord, this matter needs to be, my lord,
Well,
inquired, my lord,
all
by
right,
some-
man. That is true. It is a part of the intention since it is gone on, man. 90 days behind the bar, man. Apparently, it is less than a small quantity or small quantity, my lord. My lord, 90 days behind the bar. And in case of the small quantity, it is a bailable offence, my lord. Let him allow the bail, my lord. I maybe go on bail, my lord, at any condition, my lord. At any condition. And what my line friend, my lord, say, my lord, I am agree with this, my lord.
As per FIR, the quantity is 0.33
3 gram.
334.
Mal. And the forwarding is also same, and the Caesar is also same. That is why your lordship on the first day, my lord, asked me to bring the Caesar list. I will release you bail, my lord. It is not possible on the last day of the court, my lord, before vacation. So it is before your lordship now. Caesar is there, my lord. Already.
If you go by the Caesar list,
Yes, my lord. Then he is
it
entitled
will
to bail.
come
my lord.
around
3.08 gram, my lord, total weight.
It is the less than small quantity. So I am agree with my learned friend, my lord. Whatever was the in the case diary, my lord, photograph we do not know, my lord. At least 90 days behind the bar, my lord, we have got sufficient punishment. My lord, it is not a case that I get releasing of bail, my lord, it is a acquittal, my lord. My lord, charge sheet will be definitely filed. I have to face the trial.
And my lord,
More so, my
trial
lord,
court also
during
any
the
rejection order
my lord, that is the wrong. That is a
trial court also, my lord, while rejecting the bail petition, specifically mentioned
mention, my lord, on the basis of the affair, my lord, on the basis of court order, nothing wrong. In had there been a, it is not in the 21A, my lord. The trial court ought to have not been passed this order, my lord. So, because we have annex, otherwise, my lord, there is a question whether you have approached the court below or not. That is we have annex, my lord. My lord, I am ready to cooperate with the investigation officer. My lord, once a week, twice a week, once a month. Let them carry out with the investigation. Let inquiry be conducted. I am agree with this all, my lord.
Otherwise, the case was registered under 21C.
That is wrong. Section has been inside.
No, whatever.
My lord, yes. Yes.
because my lord, those samples were drawn before the my lord ran a trial court. So trial court has my lord definitely from
There
the
is nothing
nothing but because from the seizure list he is entitled to bail. But from the photographs, my lord, some my lord disturbing.
Photographs entry before the trial court is there. Is the inventory is also not before us.
Yes, my lord.
And how can you say that it's not there?
And this sizzle is also not seen in the trial court, my lord. To be fair, my lord, this is my lord. One my colleague sent the record, this application, my lord. I have asked him, entire trial court record, my lord, nothing, my lord. So advise, my lord, 90 days already, my lord, kindly consider. I am ready to face the trial or cooperate with the investigation till the completion of the charge.
Yeah. Mr. A.K. Hussain.
My lord.
Heard Mr. A.K. Hussain, Juvenile Counsel. Also heard Mr. What Hilali. This is an application situation. Mr. A.K. that Juvenile Counsel. That from the FIR as well as from the season list, it means that the seized quantity of the contraband is 0.54 grams, which is much lesser than small quantity. But the case has been registered under section 21C of the NDPS Act by quoting a wrong section. However, the accused petitioner was behind the bar. Since when he is behind the bar?
My lord,
from 1924, my lord.
He is behind the bar since 1904 to 2024. And till then, and thus the I also got an opportunity for controlling investigation. And accordingly, we submitted that considering the quantity of contraband that is to have been recovered from the poison of the petitioner, vis-a-vis the length of detention already undergone by the petitioner, he may be released on bail. However, he is ready and willing to cooperate the higher in further investigation of this case, and as and when his cooperation will be needed. Next part. Mr. Waterbury submitted in this regard that it is a fact that as per the fire, the quantity of contraband is alleged to have been recovered is 0.334 grams, and from the seizure list also it that after recovery of the contraband from 7 numbers of suitcases, it was weighed and the total weight of the contraband was found at 3.08 grams. But the photographs which were annexed in the case diary, it cannot be considered that the quantity which was recovered from the position of the accused petitioner was less than small quantity or small quantity rather. It can be seen that it can be seen from the photograph that the contraband may be much more than the smaller quantity or may be
it seems 6 kg, my lord.
6
kg.
it may be it is a 6 kg which is commercial in nature. However, he submitted as it's a contradict materials in the case diary. It cannot be directly claimed that the contraband which was recovered is of commercial in nature. The submission made by the council for process, and also considering the fact that there is a the contraband as per the FIR, the weight of the contraband as per the FIR is 0.4 gram, and in the same time the contraband after the and contraband as per the Caesar and weight of the weight of the contraband as per Caesar is 3.08 gram, much lesser than the small quantity, and from those materials it cannot be said that the matter which commercial quantity low is the case that it is registered under 21C of the NDPS. In view of this, and also considering the application of the fee undergone by the where it is pending?
মানে special court Bongaigaon.
To the satisfaction of special judge Bongaigaon. Let us see. Do you want to make any specification regarding
Yes, ma'am.
Matter
needs to be investigated concerning because of the discrepancies in the melody.
However, but it has to be by the special judge you want to say, or by
the SP Bongaigaon, my lord. By the SP Bongaigaon.
Verified by through the higher officer of higher official regarding the discrepancies found in FIR shown in the process. So it gets that.
Well, at release and Lordship allow bail?
Yes, you are allowed.
Well, at bail 1 rupee.
If the petitioners are from which place?
Well, it's a business man.
No, they belong to place.
Business, Sirang district.
Not the outsider, no?
No. Well, just neighboring district. Earlier it was in the Bongaigaon bifurcation of the constitutional to BTC. It is
maybe of 1 lakh.
Pardon? Yes. 1 lakh.
1 lakh. 50,000. It's a daily labor.
Daily labor, he has the extra income.
Oh, no.
He has the extra source of income.
No.
Profitable business.
In this case, my lord, I was arrested on 11/10/2022. Quantity is commercial, my lord. Now I am seeking bail on mainly 3 grounds.
Bail, yeah?
3 grounds, my lord.
Okay.
The search and seizure was made after sunset. The authorization order was not taken, my lord, which violates section 42, subsection 1 of NDPS. Although reason was given, but sufficient time was there before the IO, but that was not taken. Second, my lord, that 1 year, 9 months, 7 days have been elapsed. Trial is not completed. And third round, my lord, the 2 seizure witnesses were examined, and they categorically stated that they were not taken before making search. When they were taken, they seen that the 2 accused persons were sitting outside the vehicle. So they did not see that they were within the vehicle. So their statement is not within the purview that the contraband is seized from us, seized from me, my lord. So basically, my lord, on these 3 grounds, I am seeking bail. Now, may I read the FIR? Page 13, my Lord FIR. This is to inform you that reliable information was received by me at 4:30 p.m. today, that is on 11/10/2022. As per the information, a large quantity of suspected to be narcotic drugs is being transported from Badarpur to Mokaibanga by concealing inside a new white color Maruti Ignis car without registration number by the Kandigram road. Accordingly, GD entry was made by me at Malua PICP by GD number 158 dated 11/10/2022. There was an urgency for conducting detention and search as the consignment of narcotic drugs was likely to be transported to some unknown places in no time. Hence, the authorization from a gazetted officer as per section 42 of NDPS Act could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been obtained without affording opportunity. For concealment of evidence, facility of escape of offenders, and removal of transportation of NDPS Act substances. Ground of such belief was recorded by GD number so-and-so, Malua PSC. Then, along with the below-named police personnel headed by me, left for Naka checking at 4:40 p.m. on 11/10/2022 by GD number so-and-so, so-and-so. I, along with the aforesaid police party, arrived at Mokoibanga by our golf vehicle bearing registration number so-and-so, driven by me at 4:50 p.m. dated 11/10/2022. At 6:10 p.m., this is at night, madam, the suspected vehicle reached our Naka checking at Mokoibanga. Near END road, we have stopped the vehicle. Before starting the search, we have called two independent witnesses of the locality to witness the search process and explain the purpose of search. The witnesses are Noyan Das and Kamrul Islam. I identified myself and also offered me to be searched by the independent witnesses before starting the search inside the aforesaid vehicle and also the suspects. On being asked about the narcotic drugs, the suspect stated that the drugs concealed under the driver's seat of the vehicle. Hence, there was no requirement of searching their body and no notice under section 50 of NDPS Act issued to them. I then started the search of the vehicle in presence of above mentioned witnesses. While complying with the provision of section 42 of NDPS Act, the following items have been recovered by me from the possession of the suspected person concealed in the vehicle as well as produced by them. Total 48 numbers, black packet, so-and-so, so-and-so. The above mentioned recovered item were seized by me as per seizure list in presence of above two mentioned independent witnesses, and the packing and sealing of the item were done by me at the PO. After completion of the formalities, I along with the staff departed from the PO at 7:15 p.m. and returned to Badarpur PS at 7:35 p.m. on 11/10/2022 and deposited the seized items to the PS Malkhana. Also handed over the two implicated persons, namely Hussein Ahmad and Islamuddin. It may be mentioned that I, being the Sub-Inspector of Police, as empowered by the Gov Pravasam by notice number so-and-so, so-and-so, search, seizure and arrest without authorization. So, my lord, so this is admittedly, it is, the search was made after sunset, and my lord, the as per FIR, it was recovered under the driver's seat, my lord, from the vehicle. Now, my lord, kindly see. Kindly see the witnesses. Annexure 5, page 41. The two independent witnesses, PW1 and PW2. The occurrence took place
41.
Page 41. 41. 41.
Page
41, my lord, of the petition.
Page 41 of the petition. The positions are also available in the scan copy. Scanned copy. I have flag mark.
I have annexed, my lord. What 219?
Key underline.
Yeah.
28, no?
My lord, it is there is some defective in pagination, my lord. It is page 38. PW1 named Kamrul Islam. The occurrence took place about 5-6 months ago at about 4:30 p.m. at the turning of Mokoibanga. I have a shop near the PO and I was at my shop. At the PO I saw many people, police personnel and one alto car. I saw two people kept sitting outside the car. So my lord, it is not inside the car. I recognized accused Islamuddin. Other accused I cannot identify as I am in doubt. I and another person body searched the police personnel and found nothing. Thereafter, police opened the car and found one packet near the driving seat. The packet was packed inside a brown packet, and inside the brown packet a small black pouch, and inside the black pouch were tablets. Police weighed the tablets, but I do not remember how many tablets police found or how much it weighed. Police thereafter prepared the seizure list, seized the packets and took my signature on the seizure list and the packets. Police sealed the packets inside yellow envelope and sealed with LSC. Police also found two mobile phones, so and so, my signature and MO. Police recorded my statement. MO3 is the said envelope where police sealed the seized and materials. MO3-1 is my signature. Exhibit 3, PW1 is the photograph showing recorded the tablets, recovered tablets. Exhibit PW4, Exhibit P4, PW1 and Exhibit P5, PW1 are the photographs wherein myself, the other witness, the recovered tablets and the accused persons and the vehicle are seen. Exhibit 6, PW1 is the photograph wherein I am visible putting signature in the envelope. In cross, my lord, I am BDP secretary and have relation with police. It is a fact that I did not state to IO that I have a shop near the PO. Police already know that I have a shop near the PO. My residence is at village Sarapur. It is not a fact that I do not have a shop near the PO. I was present at the time of weighing. It is a fact that there is no photograph to show that I was present at the time of weighing. It is not a fact that I was not present at the time of weighing. There are many shops near the PO. Except me and another witness, police did not record the statement of other shop owners. I body searched predominantly. It is not a fact that I did not body search the police personnel. Predominantly, I cannot say the registration number of the Volto car. By 5:30 p.m., I returned back to my shop. By 1 hour of the whole procedure was completed. It is not a fact that I am a stop witness and that I have deposed falsely, that nothing was seized, weighed, and sealed in my presence. So here my doubt is that he is categorically stated that both the person was sitting kept outside the car, my lord. He had not seen that they were inside the car. And my lord, he is a BDP secretary, he has a relation with the police. So that witness may be manufactured by the policeman. Now next, my lord, PW2 Nayandas, who is also one of the seizure witness. The occurrence took place in the year 2022 at about 5:30 p.m. at Mokoibanga. I was in a shop at Mokoibanga. At the PO, I saw many people. Police personnel and heard that drugs were found. At the PO, I saw many people, my lord. Many people, police personnel, and heard that drugs were found. Police searched one vehicle and found drugs. The drugs were packed inside the brown packet, and inside the brown packet were small black pouch, and inside the black pouch were tablets. Police weighed the tablets and approximately 1 kg tablets was found. Two people were present and I saw one fled away. I recognized accused Islamuddin, but other accused Hussein Ahmad was not present at the PO. Police thereafter prepared the seizure list, seized the packets, and took my signature on the seizure list and the packets. Police sealed the packets inside the yellow envelope and sealed with LSE. Police also found 2 mobile phones. Exhibit P1, PW1 is the seizure list, and PW1 to PW2 is my signature. My lord, let us see now the cross, my lord. I have seen police taking out the seized materials from the car. It was an Alto car. It is a fact that I did not state to IO that I was in a shop near the PO, or that after weight about 1 kg tablet was found, or finding 2 mobile phones, or finding the brown packets inside which a small black pouch inside which were the tablet. I was at the PO for about half an hour. It is not a fact that I was not present at the PO, or no seizure was made in my presence, or no tablets were recovered from the possession of the accused person. So this is the, my lord, these are the 2 independent witnesses, my lord, and both their statements were in doubt, my lord. On the basis of their statement, my lord, their possession cannot be confirmed, my lord, from the accused person. And my lord, here as per record, my lord, 1 year, 9 months, 7 days have been elapsed. Only, my lord, 3 PWs were examined. So in delay of trial, my lord, basically, and in this regard, I would like to place some rulings, my lord. My lord, I have placed one Bhutta Singh versus State of Haryana on 16 April 2021. This is a sunset clause, my lord. In Bhutta Singh, my lord, State of Haryana, para number 10, my lord. Para number 10. The Honorable Apex Court, my lord, described about section 42, subsection 1. In the next page, my lord, I would like to read, my lord. In section number D, I would like, my lord. But if the information was received when the officer was not in the police station, but while he was on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in goods or evidence being removed or destroyed, it would not be feasible for or practical to take down the writing, the information given to him. In such a situation, he could take action as per clauses A to D of the section 42, subsection 1, and thereafter, as soon as it is practical, record the information in writing and henceforth, and forthwith inform the same to the official superior. See, in other words, the compliance with the requirements of section 42, subsection 1 and 42, subsection 2, in regard to writing down the information received and sending a copy thereof to the superior officer should normally proceed the entry, search and seizure by the officer, but in special circumstances involving the emergency situation, the recording of the information in writing and sending a copy thereof to the official superior may get postponed by a reasonable period. That is, after the search, entry and seizure, the question is done of urgency and expediency. Next paragraph, section 42. But if the information was received when the police officer was in police station with sufficient time to take action, and if the police officer fails to record in writing the information received or fail to send a copy thereof to the official superior, then it will be suspicious circumstances, being a clear violation of section 42 of the Act. Similarly, where the police officer does not record the information at all and does not inform the official superior at all, then also it will be a clear violation of section 42 of the Act. Whether there is adequate or substantial compliance with the section 42 or not is a question of fact to be decided in each case. The above position got strengthened with the amendment of section 42 by Act 9 of 2001. So, my lord, here in this case, my lord, next page, my lord. However, the arguments based on non-compliance with the section 42(2) were brushed aside, the observing that discrepancy in exhibit 14 so and so, and there was a compliance with section 42(2), the special judge coming to compliance with the provision to section 42(1) held that the vehicle searched was being used to transport passenger, as has been clearly stated by its owner, Biraram. Hence, as per the explanation to section 43 of the Act, the vehicle is a public transport vehicle and there was no need to any warrant or authority to search such a vehicle. The High Court has reversed the above findings of the special judge. We thus proceeded to examine as to whether section 43 was attracted in the present case, which obeyed the requirement of section 42 subsection 1 provision. So, my lord, here in that case, my lord, in respect of public transport, that 42 subsection 1 is not applicable. In this case, it is a private transport, my lord. So, 42 subsection 1 is applicable, my lord. Next, another Sarija Banu judgment, my lord. The Honorable Supreme Court has also observed that second page of the Sarija Banu judgment, my lord. It is pertinent to note that in the bail application, the appellant, it was alleged that there was a serious violation of section 42 of the NDPS Act. In the impugned order, nothing is stated about the alleged violation of section 42, and it is observed that it was not necessary to consider such violation at this stage. The compliance of section 42 is mandatory, and that is a relevant fact which should have engaged attention of the court while considering the bail application. In the aforesaid circumstances, having regard the special facts of the case, we direct the appellant's warrant to be released on bail on executing bail bond of rupees so and so. So, my lord, section 42 subsection 1 is mandatory. And in delay judgment, my lord, I have given my lord Muhammad Salman Hanif Sheikh. In that case, Honorable Supreme Court, my lord, in considering the delay ground, my lord, bail was granted. Another was, my lord, Nitish Adhikari and Muhammad Muslim, my lord. That in Muhammad Muslim, these are all, my lord, on delay grounds, my lord, bail was granted. So basically, my lord, I am seeking bail on 3 grounds, my lord. The seizure witness, my lord, is not on the is not having any merits. On that basis, my lord, I may be convicted, and the 42(1) is not maintained. It violates section 42 subsection 1 and delay ground. These are 3 my basic ones.
Section 42 complied or not, my lord, it has to be considered facts by facts. In different case, my lord, situation may vary, my lord. In the particular case, my lord, when police got the information at 4:30 p.m., my lord, immediately they made a GD entry and regions were recorded. Accordingly, within 10 minutes, 4:40, they left the PS to the place of occurrence. My lord, in a Nakasaking, my lord. Now, as per information, 2 persons came in a Ignis car, white color Ignis car, and after this, in presence of the independent witness, my friend has gone through the evidence of PW 1 and 2, but he has tactfully skipped the PW 3, though he annexed.
3 is not an independent witness.
Yes, but I am reading the PW3, my lord. To PW1 and 2, they have stated that they searched the body of the police personnel, then found nothing. Then the police personnel searched the car and found around 9,600 Java tablet, weight is 1.85 kg, another driver seat. And both the persons were coming in the said car. PW3 I am reading, my lord. It is annexed in the petition itself, the record also there, my lord. On 11/10/22, I was proceeded to police station at that time. IC took me along with the other police personnel for the Naka checking. There was information in respect of the vehicle carrying suspected drugs. One Ignis car of white color coming from Badarpur side to the west side was apprehended at 6 p.m. There were 2 persons inside the vehicle. The accused person present in the dock are the said 2 persons. People gathered. 2 persons body searched the IC. And thereafter the IC searched the vehicle and found 48 numbers of black purses inside the packet. So, 2 persons searched the body. There 2 persons are the PW1 and 2. Thereafter, he searched the vehicle. There were tablets inside the black pouches. More than 1 kg were found. Thereafter, IC prepared the. These are the common malad. Now, fact is that malad, in the search sheet there are 11 witness total. FIR dated 11/10/22, search sheet on 27/12/22. Total 11 witness. Charges frame on 3/6/23. Thereafter 3 witness examined. But in the LCA, last order is of 21/2/24. 21/2/24 fixed on 12/4/24 for further evidence. So subsequent to the 12/4/24, what happened? We don't know. That is not up to date. Last order is 21 February 24. So, if I assume around 3 witnesses examined till date, malad, then also, malad, 1 and 2, they searched the police personnel. 3 also confirmed that yes, after searching the police personnel, then he searched the vehicle and found commercial quantity 9,600 Java tablet, total 1.85 kg. And malad, trial is going on, but latest position we don't know, malad. And 8 more witnesses to be examined. And there is conscious position and malad 42 is compliant and malad is considering the bail. Entirety malad, it cannot be considered at this point of time, malad. 8 more witnesses to go and trial is still going on. So, malad, at this point of time, either my prayer is to reject this case at this stage, or up to that, if any other witness examined, we don't know, malad, because last order is of 21st of February. Commercial quantity, malad, yes, is until
After up to which date you have received?
last order is of 21/2/24. It was fixed on 12/4/24 for further evidence. Last order is of 21/2.
That 2 independent witnesses both were examined.
Both were examined. They have searched the police personnel. Thereafter, the police personnel. Everything complied, malad. First of all, regions were recorded. In the first GD entry, second GD entry, they moved to the place of occurrence. And secret information received that one vehicle is coming. So hurriedly they came to the place of occurrence. Because of that, results were recorded. Regarding search, malad, everything, independent witness searched the body of the police personnel. Thereafter, search made. PW3 confirmed that yes, 2 persons searched the body of the police personnel. So everything complied.
PW3 is a police personnel, 2 independent witnesses were examined. Their
yes,
deposition
he is the police personnel. He stated that
they are categorically stated that they are seen outside the vehicle. Both have seen. And they both are not engaged before making a movement. After arrest, everything, they were taken, my lord. Both independents were taken. So whole investigation is under cloud, my lord. Whole investigation. So on that footing, my lord, on such type of investigation, should I be remaining in detention where almost 1 year, 9 months, 7 days have been gone? The young person, my lord.
To consider the whole aspect, my lord,
This 3 grounds, my lord, is very genuine and
investigation trial is still going on. At this stage, my lord, my prayer is for rejected.
I have given judgment, my lord. Another one is Nitish Adhikari. That's very given.
And my friend referred the judgment. That judgment also.
My lord, Mohammed Muslim, Ravi Prakash, Nitish Adhikari, Salman Sheikh, Kota Singh,
Section
and
42 will vary
Sarija Banu, my lord.
text by text, my lord. That itself in the judgment itself.
Sarija Banu and Kota Singh categorically 42-1 saying.
Did it comply for 42 or other work?
I'm sorry, man. That was in delay, my lord. Nitish Adhikari delay, my lord. Compliance, my lord, Kota Singh and Sarija Banu. Obliged.
May I please? 438 application lordship. CD was called for lordship, CD is received lordship. FIR is at page 11 lordship. It's a CR case, later on it has been registered lordship. The bail application?
What did it say?
Later on it has been registered as a PS case lordship. Initially when the...
It's a complaint.
Yes. Long FIR lordship page 11 lordship, 11 onwards, it's a type copy. May I please, Lord? Yes, Lordship. Accused number 1 is the complainant husband and accused number 2 is the complainant father-in-law. Accused number 3 is the complainant brother-in-law. On 11/1/23, as per Islamic
Basically,
Sharia...
this is the case under section 498, 354, 376, 5.
The allegation is that Lord...
Allegation of 376 is against whom?
Against Lordship, brother-in-law, Lordship.
Against accused number here, petitioner number 2, my lord.
Yes. Actually, there is no marriage at all, Lordship. She has claimed that in her complaint, Lordship, she has entered into the marriage on 11/1/2023 as per Islamic rites and rituals. And later on, she has stated that Lordship on 18/1, Lordship, they have executed one affidavit, come declaration, Lordship, for their marriage. If it is so, Lordship, as per Islamic rites and ritual, after the marriage has been solemnized, there must be a kavinnama, Lordship. What is the need of this affidavit, Lordship? So, mainly there is no marriage at all, Lordship. She just, they were in a relationship, and later on, the main accused, Lordship, as per her complaint, Lordship, the so-called husband, she realized that he has been cheated, Lordship. She has been continuing demanding money, and later on, Lordship, his brother, the accused number 2, Lordship, filed an CR case for this cheating and challenging this affidavit also. So there is a counter CR case also. Both are pending, and as per instruction received on earlier date, Lordship, the Lala PS case 84/24 has been registered under section 354, 376, 511 and 34 against all the accused person, Lord. Now CD is there, what in CD?
Otherwise, case diary received, my lord. Regarding other allegations regarding Dowry Prohibition Act, there is no such material in the case diary, my lord. And regarding, my lord, other allegation 376/5, that is the statement of the complainant. Other witnesses, my lord, there is no such any other supporting witnesses regarding that aspect also, my lord.
Which
And
regarding?
regarding 376 and 5, that is attempting to commit rape, my lord. And that is the statement of the complainant, my lord. Initially, my lord, actually there was love affair between the, my lord, petitioner number 1 and the, my lord, victim. And thereafter, my lord, the family of the of the present petitioners not allowed her to stay in their house. And thereafter, my lord, she forced, my lord, some of the witnesses stated that, my lord, she, my lord, on a particular day, my lord, at about 2 to 2:30 p.m. entered in the house of the, my lord, present petitioner, and thereafter she stayed there for about 7 days. On the 8th day, my lord, regarding 376 and that is, my lord, attempting to, that is the statement of the complainant, but there is no such other supporting evidence. These are the materials against.
He never visited their house here.
No, interim.
No interim.
From the contents of the FIR, there is no custodial interrogation may not be required.
Yes.
Legally married, one, not then coming to one, what you want. And when they all came to know of this, what kind of cheating you want to say?
Lordship,
You have said committed that she cheated. What kind
yes,
of
Lordship.
cheating?
As per the so-called husband, Your Honor, she has been saying that this lady is continuing demanding money.
That is cannot be cheating. You have committed that he cheated you. How?
Not him, not his brother filed this CR case.
What's the allegation?
220, Your Honor.
There is no
The
case of
husband
cheating.
brother.
Initially, they were in love affairs. Thereafter, my
Yes.
lord, one affidavit. They both, my lord, one affidavit of declaration regarding marriage also. Only because, my lord, those family members of the petitioner were not accurate. Thereafter, all these disputes, my lord, occurred, my lord. Otherwise, this is not a false case that, my lord, see, my lord, unnecessarily.
Though there was no problem and subsequent to demand money. And number one, important. Also now then complaint case against the informant. However, all the petitioner can burden which it's important to subject in this regard that except the statement made by the victim that's from it as especially in regards to attempt of rape the information it was the particular love relationship number one and they were love relationship.
Yes, initially.
She regarding the marriage, is there any?
Regarding the marriage, my lord, only there is no social marriage was performed between the parties. Only one affidavit, my lord, regarding recreation. That is the.
But the submitted that, but in is that no formal marriage, no formal marriage was solemnized. However, one marriage was executed by the Petrol is available in the case diary. So, maybe complete the I investigation of this case. Because here is sufficient invalid number. Apply to the okay, there will be some directions, but by all the direction appear before the act.
They will cooperate, Lord. Sure.
Addition
Yes, in this case, page 20 of the additional affidavit. Page 20 of the additional affidavit, point 3, the details has been made out. Point number 3, NDPS case number 353, public 24, pending in the court of district and session judge, Sankadev Nagar, Ujai. Charge sheet number 63/24, dated 30/3/24.
Now, what is the case like? Forward, obviously, the CS number and the pendency of the case was not mentioned. That's why additional evidence is there. Now, at this case, what to do?
Your Lordship may kindly call for the scan copy of LCR and CD, man.
It is already a case of evidence.
Yes.
4 numbers of witnesses have been disposed of.
Already been examined. It's a case under which
21C and 29 of the NDPS section.
committed hard that additional duty everyone get pursuant to order 7 one additional ability required mentioning about the case number and the code between the average man. No, where it has been mentioned that the case registered as NDPS case number 2024 in connection with Monka PS case number 554 under section 121 29 of the pending court. The court of district and state judge Sankadev Nagar, Ujai, and the case number is 63 of 2024. Dated 30/03/2024. Further, it is stated that the case is that is of and already 4 numbers of cases are being recorded and are being examined by the all for the recording, all for the scan copy its record of number 12 or the total when it can be distinct, it has to come from Sankadev Nagar.
By this month.
By this month,
Humble prayer by this month, Your Worship, because 210 days behind the bar, Your Lordship. If possible, by this month.
Then 31/7 then. 31.
The college.
Much obliged.
It's 31/7. Scan copy of the
diary to 24. Diary card 24. Maybe it is a 438 application, Lordship. Lordship, FIR page 8, Lordship. Small FIR, Lord. Married, Lordship.
Yes.
The respectful submission is that on 12/4/2024 at about 9 a.m., my younger sister, namely
Hukumuni Khatun, aged about 16 years, went out to appear in her HS first year examination at Harshingwari College. As she did not return home in time after the examination, we searched her, but till date no information received about her. This is the allegation. And Lordship, in the FIR itself, her age was mentioned at 16 years, but I have collected her birth certificate. She was 19 years 2 months at the time of alleged incident. So,
19 years, 2 months.
2 months. And the case is registered under section 365. Found. That's the found. So she was major lordship. Even what had happened is that it reveals. So 365 IPC lordship. And subsequently she recovered lordship and her statement also recorded.
Here, Lordship, as per her full living certificate, charge Lordship with her date of birth is 12/2/2008, so around 16 years. 8.
But we collected the
Yes.
certificate when it's 12.
Now, Lordship, her 164 also, Lordship, she voluntarily went within Lordship and stayed in a hotel for 7 days, Lordship. And that is her 164 statement.
Her birth certificate, her date of birth was 12/2/2005. And she got recovered and her statement is recorded by the IO and recorded by CRPC as well as her statement. Following is granted me the privilege of rearrest. Mr. Sharma, that for birth certificate collected by the IO, she was 16 years of age at the relevant time of incident. Her authorization is available in the recorded okay, granted fair. Appear put the IO with and cooperate with the party. Bear with me for a
Wait, please, Your Lordship.
Who is the other side defendant?
Lordship, in this case, Lordship, today is the first day, Lordship. After Lordship, that condonation period, condonation was delayed, Lordship. This item is.
Condonation has been delayed.
Condon. Delay has been condoned, Lordship. Now, Lordship, what happened in this case, Lordship, this petitioner was a juvenile, Lordship. All the things, this Ellie's affair was lodged against this petitioner, Lordship. Almost 19 years ago, Lordship, affair was lodged against this petitioner, Lordship, stating that, Lordship, there was a quarrel between the informant's son and the petitioner, and another juvenile was there, Lordship. An allegation against this present petitioner that he stabbed informant's son, Lordship. Thereafter, Lordship, accordingly, case was registered under 341, 302, 34 IPC, Lordship. Then after completion of the Lordship investigation, charge sheet has submitted, Lordship, charge sheet, Lordship, under same section, Lordship. Then, Lordship, this petitioner was tried before the juvenile board, justice board, Lordship. That order, Lordship, will find on page 15, Lordship.
In this case, name of PP Assam is not shown in the cause list, so the file is not with us now.
That's what I'm asking not shown cause list.
The last order.
So you have not.
Yes, last order, Lordship, they have represented, Lordship. In the condemnation petition also, Lordship, they have represented, Lordship. But that their presence was there, Lordship.
In condemnation?
Yes, Lordship.
Condonation, Mr. Pothakur, your PP was there.
Yeah. But my lord, today my lord, PP Assam is not shown in the cause list, for which my lord, file is also not with us now.
At that apart, you have not taken steps for the response number 2.
Lordship, notice, yes, Lordship, notice was served at that time, Lordship could not trace her out, Lordship. Accordingly, notice has been sent that time. Yes, Lordship. Now this revision petition, that was not sent, but in condonation petition, it was sent, Lordship. Step has been taken, Lordship.
Today is, my lord, not the matter is listed, criminal revision petition is listed, my lord, not condemnation petition.
Condemnation already disposed of.
Condonation was disposed of. Now,
what happened in this case, Lordship? He was convicted under 302, Lordship, and sentenced in 3 years imprisonment, Lordship. That order was challenged before the appellate court, Lordship. Appellate court has upheld that order. That appellate court order, Lordship, will find on page 22, Lordship.
What question is that in, IA condonation,
yes,
this state was there for response number 2.
Yes, ma'am.
And the HLPP
Yes.
also appeared.
Yes.
State also appeared in I while conducting PP.
Yes.
Now this is a revision, and apart from revision, they have filed one I.
Right.
I is for most probably
Was suspension of the sentence, Lordship. Because there is a direction to appear before the juvenile board, Lordship, within 15 days, Lordship. Now, Lordship, this petitioner is almost 34 years age, Lordship. Now, whether
now
this...
what I mean to say, for 3 years, what kind of punishment was there?
302, Lordship. In 302, 3 years.
302.
Yes, Lordship.
302.
Yes, Lordship.
But whether he was asked to serve any community service or any...
No, that was not the Lordship. Kindly the appellate order, the Lordship will find on page.
So, apart from the appellate order, now come to the order passed by the juvenile justice.
Yes, that order I have already annexed, Lordship.
In which page?
That order, Lordship, will find on page 20, Lordship. He was directed to special home, Lordship. sent him to appear for the special home, Lordship, served the 3 years punishment, Lordship. Now, Lordship, he is a Lordship, 34 years of age, Lordship. In that regard, Lordship, I have placed certain judgment, Lordship, where Supreme Court has, Lordship, set aside that, Lordship, punishment part, Lordship. May I please?
So he was, just a second. He was sent he was sent for special home in for 3 years.
Yes.
For the
Yes.
conviction of 302. Now I guess that order was you don't have anything filed.
Yes, my lord, fine.
So what is your position? You want to submit?
Because otherwise, my lord, now he is taking the ground of juvenility. Some of my order of the my lord, juvenile justice board as per his
Yes, yes.
record
juvenile,
is there.
he is the juvenile.
Even yes, my lord, thereafter, my lord, now he is already convicted. While my lord, under section 302. So now the question of juvenility was also after considering all those things, my lord. Now the present position is that he is convicted under section 302 for 3 years. So my lord, delay was condoned. So my lord, considering the my lord, my prayer before your lordship, otherwise conviction is for only for 3 years. Otherwise delay, my lord, is sorted by records. Because today, my lord,
The order, although yes, he was a juvenile and punishment was for 3 years.
3 years.
Penalty. With a direction to and sending to special home.
Yes.
Authority against that order, they preferred an application before the appellate authority.
Yes.
It was upheld.
Yes. So,
now
my lord,
it's-
while the appellate authority has also upheld the order of conviction, my lord, he is now, so now at this stage, without going through the, my lord, LCR, so my prayer before lordship at this stage only my notice may be issued and LCR may be called for.
Complete. Now, Lordship, regarding that part, Lordship, there was
Because
a
that
direction
order
on
was
page
also upheld.
28, Lordship. He was asked page 28.
Because he is against the appellate order, my lord, here.
Now he is against the appellate order.
Appellate order, Lordship. Now, page 28, Lordship, there is a direction. Para 18, Lordship, page 28.
The order of the appellate court was passed on in the year 2022, that is 24/3/2022.
Yes, Lordship.
Till now, he has not surrendered himself to the
No, Lordship. Before that, Lordship, he had challenged, Lordship. He already challenged with this appellate order along with the condemnation petition, Lordship. The case is sub judice before this High Court, Lordship.
Now he
yes.
what is the urgency?
Yes, well, there is.
For since last more than 2 years,
Now,
but
Lordship.
here and there, and now what is the urgency?
Now, Lordship, that's why, Lordship, I place the judgment of this Honorable
What
Supreme
is
Court.
the urgency
that
from your side?
because, Lordship, there is a direction, Lordship. Now, the Lordship,
You have
continuous, Lordship.
the direction for last 2 years.
Now, Lordship, the case is pending there, Lordship.
More than 2 years, you have violated the order.
Yes.
You are now not.
But, Lordship, I'm
what is
challenged.
the urgency? I'm asking, what is the urgency?
Because, Lordship, there is a, I have to.
No urgency.
Because, Lordship, I have to appear. Because there is an order, Lordship. Since
You are
case
not
is
appearing.
pending, Lordship, this case was
That's
pending.
what I'm saying. You are not appearing for last more than 2 years.
Lordship, this case was pending from 2022, Lordship.
Whatever, you are not appearing. You are
Lordship,
avoiding
I have
appearing before the court for last
Lordship,
more
that
than 2 years.
I am challenging that order, Lordship. I am prejudiced that order. That's
What is
what
the urgency I'm asking you?
urgency because of there is
Then
a
what is the urgency?
there is a standing order is there to appear before the court, Lordship.
He is playing away from justice for last
Playing
2
away-
years, my lord.
That's why, Lordship, in the Supreme Court.
Urgency then.
Lordship, may I place kindly peruse this?
Order should be different. But the urgency, I'm not finding any urgency. That's what I'm saying. Because you are avoiding, you are convinced since last more than 2 years. 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 2 years will see afterwards.
Yes.
Now tell us what is the urgency.
Because Supreme Court in this case, Lordship, what happened, Lordship,
Actually,
that
my
case
lord,
also, Lordship.
he needs to first surrender before the trial court. Only thereafter, my lord, this revision, my lord,
If Lordship, that's why Lordship, he is challenging that appellate order, Lordship. If he has surrendered, Lordship, there is no question of challenging this in the
No,
appeal.
I'm not
Lordship.
finding any urgency. That's what I'm saying.
Yes, ma'am.
You have challenged the order. You have come before this court. It's okay. Now we'll see to it.
Because there is a order, Lordship.
No, urgency I have not seen. That's what I'm saying. For more than 6 years, we just
Because case is pending, Lordship, it was not listed, Lordship.
urgency I have not seen any urgency. Anyway, issue very quick. So at this stage, whether notice has it's what happened.
Yes.
Because otherwise in IA, connotation notice was already was there.
Yes.
It was served directly, but
Yes.
still it was not. But as per procedure, most probably notice
Yes.
that.
This petition also, your lordship may issue notice, and it can copy of LCR may be called.
Can copy well will be, but by that time you can dispose of the IA.
Yes.
Let give a date for disposal of the IA. Revision will be there.
Yes.
All party LCR हो जाएगा. Arbitration also court party. But you see the further it is in that game of the accordingly it is submitted to Mr. Water. The file is not for him as their name was not reflected in court. It is according to that however, considering submission made by the learned council, the IA along with IA number
351.
351 listed along with what for I will have to dispose of. I'm just giving you time so that you can see just orders are the judges are there.
Yes.
Yeah. So here that 3 years of conviction was there against that appeal. Appeal was then appeal was also complaint findings were there. And now I for suspension.
Yes. Yes.
So the next date we are giving you a short date.
Yes.
Short date in a sense by the end of this month.
Yes.
But the paribar 30. We are giving you 30.
Yes.
Issue notice also, and if LCR is also not received, because I just asked Mr. Water to prepare, because the government, state has no any file with them in fact. The name is not reflected, but direction is also there for reflection of the name of the PPR. And that apart, this matter will be disposed of. So you just remind us in the morning hour, like today, just for application. So let it be on 37. 37. And we are keeping this thing.
Yes, yes.
This has come for IA, my lord. The prisoner was convicted under section 304, part 2, my lord, for part 1 under for 5 years, and the final rupees.
Part 1.
Part 1.
Part 1.
What is the deceased happens to be his wife, my lord, and FIR was lodged way back on 29/8/2019, my lord. The lordship will find the FIR at lecture 1, page 22, my lord. It says that I beg to inform in appeal.
No, my lord, otherwise LCR is there, my lord. I have not done for the LCR.
For the judgment itself, your lordship, all the witnesses have been examined, my lord. They have not said anything, my lord. She was a drunkard in condition, my lord. And actually, there is no evidence of 304 part 1, my lord. Though it was registered under, your lordship will find the FIR, my lord. He says that my sister Pallavi Borgohai got married to Tilok Kaur of Mothiang Singagao on 29/8/2019 about 8:30. My nephew Sironjibi Kaur informed me over phone that his mother expired immediately. I went to my sister's residence, saw her lying dead, and I saw cut injury of her dead body. Our death was caused by some injuries, and my sister was caused by her husband. I pay kindly appropriate case. Accordingly, case was registered under section 302. My lord. 302. And now what after recording the evidence of witnesses, my lord, they have the additional session judge, my lord, convicted me, my lord. 8 witnesses were examined, including the IO and medical officer, my lord. And thereafter, I was convicted by judgment and order dated that your lordship will find that is 7/12/2023, my lord. That is the next schedule, page 26. And the learned session judge, while in the judgment itself, he has described the evidence of witnesses, my lord. That is, your lordship may kindly come to page 32, running page 32, my lord. Running page 32, that PW1 Sironjib Kaur, the son of the deceased, my lord. That accused Silok Kaur is my father, informant Jitul Kaur is my maternal uncle, deceased Pallavi Kaur was my mother. The incident occurred on 29/8/2019. On the day of occurrence, along with his friends, went to the pond to catch fish throughout the day. After pumping water, they bought fishes. Then on 11 when he returned home, saw his mother lying dead. She asked him for drinking water. Accordingly, he and his father fetched her water. Thereafter, he went to sleep. Next day, he went out for morning walk. During the course of morning walk, he sat under a tree. While he was sitting there, his father went and told him that his mother was not speaking. As such, PW1 accompanied him to their house, see his mother. When he came to saw his mother in lying dead, and his father went out to the meantime neighbors were called. So that is the story of the. But he was declared hostile, my lord, by the prosecution. And if your lordship come to page 34 in cross-examination, page 34, paragraph 9.3, my lord, down below, my lord. He stated that he saw the dead body of his mother inside the room. At the time, he did not see blood stain anywhere in the room, including clothes. He accompanied the police to the room where dead body of his mother was lying. He stated about 3-4 days prior to the death of his mother, she did not prepare a meal for them. During those days, she was mostly on her bed. She had a habit of drinking liquor. At the relevant time, his father was working in an LP school teacher at Galeki, which is 24 kilometers. About 14 to 15 days prior to the death of his mother, his father got 11,000 as an area. His deceased mother was a habitual drunkard. As such, he used to fall on the road. At the time of the injuries, where over the dead body of his mother were old one. As his parents were habitual drunkards, he used to remain away from his. Then comes the informant, my lord. Informant at PW2, Jitul Borgwai, page 35, my lord. 10.1, your lordship will kindly the cross-examination. He stated that the hazard was written by some member of BDP who was present in the place. He does not have any knowledge about its content. He simply put his signature. PW said he used to visit the house of the deceased occasionally. He does not know the cause of death. His nephew simply did not tell him about the cause of death. Accused as well, deceased sister were addicted to liquor. He hardly visit the house. From the villagers of it, he learned that she was often under influence. He used to quarrel with the villagers as well as he sustained injuries by falling on the road and other areas. Similarly, Deepak Gorguhai, my lord, he also he was a seizure witness to some clothes, my lord, and he was an inquest witness also, and he also made a similar statement. And the doctor was examined as PW4, my lord, page 37, my lord. There the doctor has given some lacerated injuries, my lord. Clotted blood was found in a temporal area of the scalp, 6 centimeter, 2 centimeter, and the visual was there, my lord. And according to the doctor, these injuries were 48 hours. That your lordship opinion part, my lord. That page 40, my lord, paragraph 7. In his opinion, the cause of death of the deceased due to coma as a result of head injury is a postponement in the so-and-so doctor. Then he stated he found the multiple injuries. But there is no possibility of sustaining injury by falling on hard substance. Injuries are found deceased were recent. Black color injuries indicate time of sustaining within 48 hours. Then Jointer Kaur, he is also an elder brother of the deceased, my lord. He says that in cross-examination, my lord, that your lordship will find at page 13.1, page 41. That he stated he has no knowledge how and what disease has died. He also doesn't know how disease sustained car injuries. This was a drunkard frequently under influence of liquor. She was a habit of creating noise and disturbance in her
About 2 days prior to incident, deceased was found lying on the bank of Rajmai Pukuri. From there, family members of the accused brought her to the house of the accused person. 24, my lord, PW 6, my lord. He also, on cross-examination, he has stated, my lord, page 43, my lord. He heard about 2 days prior to occurrence, death of deceased was found lying near Rajmai Pukuri under influence of liquor. From there, family members of the accused brought her to the house of the accused person. He had no knowledge that under what circumstances deceased has died. Then now the Ranlet court below, my lord. What has happened? He has that your lord, finding your lordship may kindly see, my lord. That finding your lordship at page 51, my lord, paragraph 28. He has presumed that it was caused by her husband, my lord. That is the thing, my lord. Page paragraph. It appears PW1 to PW7 did not see the alleged incident. From the evidence, Glister here on the date of the accused was on the house with his wife, Pallavi. The circumstantial evidence appearing about the PW's indicates the accused caused grievous injury to his wife by physically assaulting him on a vital part of body at the time of occurrence. Accused was with his wife at his house. No other person was present. Apart from this, the statement of PW given to duly exhibited so and so. So that this finding my wife is totally based on presumption. Nowhere any witnesses said that he assaulted him. And injuries were 48 hours old, man. She was found in a drunken condition near a river, man. She fell down somewhere, man. They brought him. And there was no blood. It was all injuries, my lord. And there was hemorrhage inside, my lord. As a result, she died, my lord. Then you will, after scrutiny, it is evident the deposit court was not willing to plead so and so, it did not state the facts so and so. Considering about this court of view that this disease did not occur as a result of habitual alcohol consumption, conclusion can be drawn from PW who equally indicates the presence of multiple injuries during cross-examination, despite there is no possibility of sustaining injuries. So it is impossible that injuries were sustained to a fall on a rigid surface, considering the nature and recent time frame in which they are documented. From testimony, it is apparent. Then he comes to 313. I have not given a specific reply. He says the accused failed to furnish credible and reasonable explanation pertaining to the circumstances leading to the death of his wife. Then finally, my lord, that as he failed to discharge his obligation under section 313, this trial court, my lord, convicted me under section 304 part 1, my lord. My humble submission, my lord, your lordship will find that, and he has taken to some incriminating circumstances, that is page 55, your lordship may kindly see. From the oral testimony of witnesses, the deceased were accused by a husband and wife, living in the house of the accused. So and so, deceased was drunkard, habit of drinking, disturbing the family. The accused were frequently used to enter the quarrel by consuming liquor. So and so, was lying dead. So and so, and notice cut injuries. So and so, but there was no. But these injuries were caused. Nowhere, none of the witnesses said that it was caused by me, man. And the son itself says that she could speak. They gave her water at 11 p.m. And she was not in a conscious. And there was witnesses said she was lying in a unconscious condition about 2 days prior to the incident. Man. They brought in an unconscious condition. So under such circumstances, how this court can convict me under section 304 part 1, man? Your lordship may kindly see. It is not evidence where I have assaulted them with causing these injuries. No evidence is there. So based on presumption, the court cannot convict me, my lord. Simply being my husband, my lord. That, and my son is also there at that point of time. And she was alive on the night. They are giving her water also. And there was no blood. It was not a recent injury, my lord. Injury were prior in time, my lord. Say about around more than 48 hours. The doctor has also explained that it was not a face injury, my lord. So considering the nature of injuries, also the manner in which the occurrence took place, and the deposition made by the witnesses, in no case under section 304 part 1 has been made out. Absolutely there is no evidence. The findings arrived by the court are totally perverse, my submission, my under such circumstances, I am entitled for suspension of sentence, my I already, since the date of judgment is on 7/12/2023. I'm inside, my I'm a school teacher, my profession, my lord. I have a family to look after, my lord. My son is also there, my lord. Had it been a case, my lord, the injuries were face matter would have been different. It has come on evidence that she was drunkard. She used to habitually drink liquor. She used to fall down in the road, my lord, after having liquor. She was found in an unconscious condition near the river Rajmai. She was brought to the house of the accused thereafter. So, concerning the nature of the conduct of the deceased, my lord, prior to the occurrence, and the way she used to behave, there's most likely because of her conduct, my lord, she has received the injuries. And the injuries are not fresh. There was no blood. No blood stains was found. And because of hematoma, because of subdural hemorrhage inside the brain, she died. Because of the injuries sustained early. So concerning the nature of the evidence as well as the nature of the evidence that is adduced by the prosecution witnesses, I pray, my lord, the sentence imposed upon this honorable court may be, by the trial court may be suspended.
Yes, my lord. Here informant is PW2, my lord. PW1 is, my lord, later on he is the son of the, my lord, victim, later on declared hostile, my lord. And PW2 initially, although in the my lord, contents of the affair it reflects that while he came there, my lord, he saw some of the injury mark covered the dead body of the, my lord, deceased. But later on in his evidence, my lord, he stated that there I saw the dead body of my sister Pallavi Kaur lying on the bed and covered with cloth. In the deposition, he has not disclosed anything about that injury marks. That is, my lord. In fact, he stated that from the villagers of my deceased sister, I learned that she very often under the influence of liquor, but that is the statement of the PWT. So, the contents of the FIR and the deposition of the PWT is, my lord, something, my lord, dissimilarities is there, that is fact. But regarding, my lord, the deposition of PW4 is the, my lord, doctor who conducted the, my lord, it is not nowhere it is specifically stated that whether those injuries were, my lord, old or, my lord, fresh. But here the specific opinion of the doctor, my lord, there, your lordship, from the injury marks, my lord, it reflects that more detailed description on injury or injury, my lord. Dead body of a middle-aged female, rigor mortis is present. Bruise of tissues around both eyes measuring 8 cm into 7 cm east, which is blackish in color. Multiple bruises present all over the body. Fracture of 4th, 5th and 6th rib seen over right side of back of the face. Deep lacerated injury as described seen over left temporal area of the scalp, my lord. With fracture of underlying temporal bone left seen, there is presence of clotted blood in bracket, my lord, 150 ml in cranial cavity with torn meningeal vessel seen. So lacerated injury present over left temporal area of brain. So ultimately, my lord, opinion of the doctor is that, in my opinion, the cause of death of the disease is due to coma as a result of head injury. So in fact, my lord, if he, my lord, prior to the, my lord, date of the incident, if he, my lord, the deceased person received any head injury, then immediately on that day itself, my lord, she need to be, my lord, admitted in hospital, because that was, my lord, because of that head injury, ultimately, my lord, the victim died, my lord. So from the PW4, my lord, statement of PW4 supports the, my lord, case of the prosecution, my lord, clearly that from the opinion also it reflects that cause of death is head injury. Nowhere it is specifically mentioned that whether the, my lord, injury were fresh or, my lord, old. And, my lord, one another important point regarding evidence of, my lord, one of the other witnesses also stated that he also saw
PW5. VDP secretary.
VDP secretary.
Last time, I believe.
So he stated that I found the deceased lying dead on the PW5 on the bed of her bedroom, facing downward. I noticed cut-like injury on the backside of the right shoulder of the deceased, but there was no blood stain on the said injury. Regarding that, he has also specifically mentioned regarding some injury, my lord. But ultimately, doctor has opined that, my lord, that was due to head injury, my lord. And that it cannot be said that that head injury was prior to the date of the incident, because if that would have been in the date of prior to the incident, then definitely on that day itself, this is need to be required to be admitted in the hospital. But thereafter, after 2 days, this incident occurred and this is died.
One fact remains that witness that she was found in unconscious state beside the river, man. That witnesses that they have brought him today because she has got received the internal injuries. There was no blood stains, my lord, in the dead body. So naturally, there ought to have been treatment. No treatment was given. She was in drunkard condition, man. That is the problem.
This is an application. And section 59 for part by Danish Session Justice Chagar in case number 1 bracket of SN 2019 arising out of Nazira PS case number 380 2019. Where the accused appellant present appellant was convicted under section 04 part 1 IPC and sentenced to undergo RI for 5 years and pay fine rupees 10,000 in default aside for another that he had already paid. He received an order which is pending. Further subjected that during the prior case, all most of the cases were examined by the judge, including the eye and the medical officer. But not case, rather from the witnesses, the was and she out of and for and under she could prove and even used to well not below for the consumption over consumption. PW1, who is the son of the skills, also also contradicted our own difference. As per him also did not find any injury or fresh injury mark in the body. He further submitted that there is no evidence.
Yes.
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 He submitted that there is no fresh injury or that at the time of admission of the at the time of PM rather she died due to clotting of blood in the died due to clotting of blood or out of right then.
Dr. PW Finance. PW Finance meet up.
Died due to coma as a result of bleeding. But also it is when she was found lying unconscious in the bank of bed. She was brought in the house and subsequently she died out of consumption of the. She was died. But the patient tells on that he might that sustain injuries caused by assault conduct by the accused appellant. Accordingly, on the basis of such presumption, and on the basis of such presumption, that the judges up to 304 part 1 IPC. Accordingly, what was submitted at the first submission from succeeding the collected copy for the sentence can be suspended by under section 89 chapter. Mr. Bott submitted in this regard that is the fact that some of the done which one and the PW also different made between the FI post of however from the evidence of it it is seen that it sustained multiple injury even in this is fracture injury on her chest as well as temporal reason fracture bone of reason, and it is opined by the doctor that her death coma as a result of the head injury. Was in the habit of drinking, or she might be a drunkard, but her date is not for her consumption, liquor consumption, but it was due to injury sustained by her. Injury sustained by her, which is evident from the evidence of the doctor, that is the according to the is to suspend the sentence at present by under superiors. The evidence is
Evidence, well,
huh?
Evidence I have not, I am for no judgment I have given. Evidence is there, my lord. I got a copy of the evidence. And certificate copy में anyway.
I find it to
Hmm?
continue with this suspend that suspend the order for traffic rather accused happen complaint according operation of judgment and order dated 7/12 brought by London Session Judge Simsak in with number 113 of 2019 arising out of Nazira Police List number 3 completely under section 4 part 1 article thereby still state in disposal of by completely and further he is allowed to go on break well 20,000 with one series like a restriction of land session the above okay, your petition is allowed and it made urgent number also for body that's this it's a real estate
Okay.
I
May I please, Your Lordship?
oh Baba got for us. It should be come before appropriate bench.
This appropriate division bench, XMLA, my lord. X. There is a notification as flag X, my lord, in the file. As per the Supreme Court decision in Ashwin Kumar Upadhyay, my lord.
It should be before division bench.
Appropriate division bench, my lord. There is a division bench created, my lord, for this.
And last order also, why they have released, he has done
Yes,
it.
but
In the last occasion also, there was an order for listing it before the appropriate bench.
yes, Lord. And even Lordship, in earlier order, there are two states, Lordship. Some matters, orders are passed from the division bench. I found some orders from the division bench also. In earlier, in 22 maybe, Lordship, or 22, 23.
2-3 times it has been listed before the division bench.
Files are there. Two numbers of files.
Yes.
Some orders.
Before that it was before the division bench only.
Yes.
In 2-3 occasions.
Yes. Then there suddenly it has come to the single bench.
That apart on the last occasion also.
Yes, appropriate bench.
Yes. Placed before
Appropriate bench.
Justice Count.
Yes.
And order was passed that it should be appropriate bench.
Yes, Lord.
Like and he has done same thing.
Same thing, Lord.
the bench appropriate, instead of appropriate bench, can be mentioned before division bench, appropriate division bench?
Yes, what my learned friend has stated as per
Notification.
that notification is available.
Ashwin Kumar Upadhyay versus Union of India. Please.
But earlier some orders passed by the division bench only. Some orders are there available there itself. There's some orders passed by the division bench, I think, Lord.
Yes, yes, some
Yes.
orders are.
Yes.
And the notification which is Black Market Act, there also the division bench comprising of this also will monitor the process of execution. That is different.
Yes. But here the matter is that, Lordship, here the petitioner is the informant in this matter. He is not the accused part. He is the informant. Because he was aggrieved by an order passed by the learned magistrate, because the FR was filed by the police and that was accepted by the judicial magistrate. Ordered by to challenging that impugn order, petitioner is before his honorable. Petitioner is not the accused part. He is the informant in this matter.
Okay, then the matter needs to be clarified from the registry.
Yes, Lordship. Yes, Lord.
Travel by the but the question is that prior to this date,
Yes.
the matter was listed for division bench.
Yes,
I also
2-3 occasions, Lordship, it is passed by the division bench.
Yes.
One occasion on last date it was listed before the single bench, my lord. Last date only one occasion it was listed
yes,
on
yes.
the single.
Yes, yes.
On
Prior to
15/6.
it was for division bench.
Yes.
So we'll pass the order before division bench. In the meantime,
Registry will verify.
registry and make it clarify that
Yes, yes.
whether
Yes,
it can be. Is there any other thing,
Yes.
reason for listing it before?
Yes,
division
yes.
bench?
Yes.
Okay, so we use the matter before division bench. Interim was there, any?
Interim is there, my lord.
Till time interim will be continued. And we also verify as to why the matter is in spite of the this court on 13/6/2024 for listing the matter before the appropriate. Please check on it. Okay, it will be listed. Interim should be continued.
What? 7th of month.
May I please, your lordship?
Yeah, please do. Lordship, I am representing the loan respondent. Sole respondent. Lordship, in this matter, we are to file our affidavit in opposition. But our affidavit in opposition is ready, but we could not file because the respondent is engaged with the treatment of his elder brother. So, Lordship, we are praying for 2 weeks' time so that we can file our affidavit in opposition.
Yes, Lordship.
You are Miss?
M. Zomonpui. I'll write it down, Your Lordship.
You are appealing for BD Kwar. You are appealing for BD Kwar on behalf.
Yes, yes, Your Lordship.
Appealing on hard. BD Kwar. And on behalf you are Mr.
I'm A. Nandi appearing for D. Nandi.
Submitted that they have already prepared their affidavit in opposition. However, it could not be filed due to as the respondent is in the treatment of his elder brother and is submitted, but he needs the petitioner, the respondent needs some more time to file the affidavit in opposition. Considering the prayer made by the learned counsel for the respondent, is the matter after 2 weeks. By the time, is there any interim was there?
No,
There
Your
was no
Lordship.
interim.
It will be listed after 2 weeks.
Good. Much obliged.
Obliged.
Please, Your Lordship. This is my lord Jimma petition, my lord. Challenge the order case 24, Lordship.
In this matter, it is came before this honorable court on 23, Lordship, last on 8/23. It is 14/9/23. 14/9/23. And earlier occasion, Lordship called CD along with the Caesar list. But I have confirmed from this office, they have not received. A short date may be given. In the meanwhile, we will receive the CD.
See, this matter is pending since 2023.
Yeah.
But till now, why CD or whatever report, why it is not there? Is it a casted date? No.
No, Lordship.
No, not
No,
no,
Lordship. In this regards,
no, pending this long.
yes, maybe
Yes, pending long. Last 23 Lordship. It is I have found is 14/9/23 last.
relying on judgment, Lordship.
FSL.
On 20/06/2023, an order was there for directing the investing officer to collect the mobile phone of the petitioner for forensic. So it was with the forensic science laboratory.
That time.
Correct.
That time.
But
As
as
per the
per
record.
that, those were sent back from the FSL or
That report is not with us. That instruction we did not receive. I informed the office, but
so your petition for Jima is for 2 mobile handsets.
Yes, Lordship.
Different people we need the report. Otherwise, what kind of this is Sundar Bhai. Sundar Bhai is okay, but this matter is a bit different because 2 mobile handsets were there, where some 67 IP is also there. Report should come. We can further propose notice can be given to the I concern. But that, prior to that, do you have any information that you have taken step or you have issued signal to the
23 February morning.
the IO for submitting those things? Is there any?
here, but on 15/9/23.
My lord, the mobile has been seized at the time of my arrest, my lord.
Yes.
My lord, my lord, neither they have filed any affidavit. My lord, my mobile is still under their custody. What is the reason behind keeping this mobile for years after years, my lord?
That's what I am just asking. It is the 2023 matter.
My lord.
The reason is pending this matter.
My lord.
But till now they are not in a position to file any
Affidavit, my lord. And the magistrate.
First initial order that is on.
My lord, there is judgment. This one is judgment.
Yes, I have.
My lord.
Sundar Bhai is there. 21 to 2023, one order was there. They obtain instruction from the IAS whether it was possible for downloading those videos or whatever.
Yes.
Or if it is supported with any 65B certificate and all. In as per order dated 21/02/2023. But since then it is pending. I don't know why.
Yes, a long time. Okay, maybe a short time. We will try to take the report whether it has received from the FSL or not. Very short time.
Solution and it might have handling the IO. The IO, comma, is there along with the Z and the FSL report is not in receipt from the IO. This content is certificate is started constituting submitted present petition is pending since 2023 and 2 mobile handset of the was seized at the time of his death.
At a
According to the subsequent
time.
there will be two mobile handsets that no more
Plate number
from the audio files that is stored that the IO could not find report case diary along the use of the FSL and whether these are required for further research for the purpose of further research or not. French commander issued a report to the IO calling for the release of the report from the FSL in response to the immunity subject of the reports. In the meantime, it had required the matter over and for the matter I as to whether they have received back the mobile handset from FSL which was then for yes, you can take very well instructions from the IO also.
Lordship.
And we are calling for the case diary may not be so required.
Yes, but the report, whether from the FSL they have received or not. That part.
Lordship,
and whether the investigation purpose and matter.
Yes.
Date may be fixed, my lord.
Yes.
So that it can be disposed of in the, my lord. Observation may be that the matter may be disposed of in the next date, my lord.
Yes.
Okay.
24 की July. Yes.
24. 24 to the
Develop.
Farmer is everything for the respondent.
May I please, Lordship? My lord, here I am wife, respondent right. Actually, this division petition does not lie in view of section 397(3) of CRPC, because in both the courts below, the husband lost his case. Now there is a due of rupees 4,95,000, and out of this, husband has paid only rupees 47,000. Husband is a service holder, recently retired. So, my lord, my submission is this: a huge amount is lying vacant, lying to be paid to the wife, and in a case, this husband was a head assistant under BDO Gosaigaon. So, the director of Panchayat may be directed to deduct the salary or pensionary benefits and to be paid to the account of the wife directly, and there is such type of order of our High Court. And listed these are the two orders. So, Secretary, that was Education Department, this is Panchayat Department. So, my life has become completely miserable. Out of 4,95,000, only 47,000 has been paid. And that too, sometimes. So, my lord, my prayer is only this: in this manner, I will die.
Whether there is any stay regarding the,
No stay from anywhere. And
so
both
have you approached the trial court below because there is no stay?
No, trial court, we approach trial court saying that you pay. Why he is not paying? but no drastic action is taken against the husband. So High Court, in similar case, High Court taken action that the secretary, in that case, that was the teacher. That's why the Secretary Education Department was asked to comply with the order of the court that the salary should be paid to the wife's account directly.
Okay, it's okay. But I'm asking you is if there is no stay at all, have you approached the learned trial?
Yes,
Bureau?
there
What did
is
he say?
there is specific order, madam.
Where is the order?
Specific order. First, Lordship may kindly see page 20. This is the first revisional course order. Page 20. Judgment is written in separate sheets and delivered in open court. For the reason indicated, it is found that the learned trial court has committed no irregularity and impropriety while deciding the points for determination that the respondent wife is entitled to get maintenance from the petitioner husband. Moreover, considering the status of the parties and the cost of living, I find the quantum of maintenance decided by the learned trial court as proper and reasonable. Hence, the impugned judgment and order of the learned trial court warrants no interference. In the result, the revision petition is dismissed. Now, Lordship may kindly see the order of the learned trial court. Operative portion may be seen by Lord page 70. It is filed by them, but it is reflected. It is filed by them. The kindly say now, my Lord page, only one order, cunningly they have filed only one order. Kindly see page 13.
31.
Page 13. Page 13, para 5. Upon going through the material and record, as well as evidence adduced by both the parties, learned CGM, Kokratar passed order dated 16/8/22 directing the petitioner to pay rupees 9,000 per month as maintenance allowance to the respondent from the date of filing of the petition. So, then the order of the learned CGM Kokratar allowing the monthly maintenance to the respondent is challenged by the revision petitioner on the ground that learned CGM Kokratar passed the order of payment of maintenance in favor of the respondent wife without properly going through the written statement submitted by the petitioner. The petitioner retired from his service 5 months before filing of the petition by the respondent, and he did not receive a single penny towards provisional or regular pension. Learned trial court has failed to give notice to the averments to the effect that petitioner has been suffering from various chronic diseases. So, my lord, these are the common factors, but the main thing is para 8, my lord. It appears that it is admitted fact that the respondent is the legally married wife of the petitioner. In her evidence, the respondent PW1 has deposed that the petitioner husband was having illicit relationship with his maid servant, and in the month of October 2018, when she raised objection, the petitioner husband driven her out from his house the respondent wife has no source of income and unable to maintain herself. In the cross-examination, Procedural 1 has denied the assertion that she was suffering from any neurological problem. So, my lord, he has taken a very unfair means that I have some neurological problem. If wife has some neurological problem, then it is his duty to treat her. Instead of treating her, he has taken the shelter of maidservant. So, here in this case, my lord, the first trial court's order is not annexed intentionally, but it is reflected in the first revision court's order. So, at present, my lord, 4,95,000 is due. Out of this, only cases of my lord, that is 2000 cases of 2000.
But while order dated
17.
18/10/2023, you were directed to approach for the recovery of this. You have not taken any step. That's what I am asking you. As per order of this court dated 18/10/2023, the respondent was directed to approach the learned court below for recovery of this. She is at liberty because there is no stay order.
There is no stay order.
Stay order was not passed. Thereafter, after the passing of this order, have you filed any application for recovery of the area amount?
That information I do not have at present.
But the question is that you have filed against this revision petition has been filed by the petitioner, challenging the quantum or whatever.
Whether she has approached the trial court or not, that is the question.
Quantum of the, and they also prayed for an interim order to stay the most probably the proceeding order. That was rejected. That was rejected by this court.
Yes.
By the order dated 18/10, and
Yes.
it is clearly directed to you. The respondent wife shall be at liberty to proceed against the present petitioner for recovery of the area as per law before the learned trial court. So you were directed to appear before the learned court for recovery of source. Have you filed any petition?
Yes, my lord. I have sent a message by the court, the lawyer at Kokrajhar, that we have approached, but court some amount she pays, and husband pays, and then takes that. In this way, the things are going. Whether in writing I have to bring something, whether he has filed any petition, she has filed any petition for recovery of the amount.
Yes, because
For that, my lord,
the trial court below has the authority to deduct the directly the amount
Yes, I know.
at a fixed amount from the, because he is the not a salaried person, he is the
Retired
person. So there are
But
some
even retirement, he is getting, as I have information, nearly 38,000.
38,000. So definitely one amount can be deducted. But deduction is that when he was in service, that time it is easier for the department to deduct the amount and direct. But it is a retired person. So there may be some sort of
approach.
So that's what I am asking you.
Lordship may kindly fix on Friday. In the meanwhile, I will bring.
Friday may not be, make it on Monday or Tuesday. Till Friday.
It may be Monday, my lord. No, Tuesday I will go outside.
Okay. We are listing it on Monday then.
Monday.
Okay. You just take instruction and please. Because we were given
Yes, I
to
understand.
approach.
I understand. Otherwise, this revision does not lie under section 397(3), because in both the courts below he has lost the case.
Contrary. Heard Mr. M. Mahmoodi learning council for Mr. Mahmoodi. He take some instructions from his plan accordingly. The marriage is listed on 27. Okay.
Monday.
Monday.
I love that.
May I please, Lordship? Lordship, by this application, Lordship, FI date 11/6/2023, Lordship, in Kajigaon PS case number, Lordship, 49 of 2023, which was registered under section 342, 506 IPC, reduced section 4 of the POX Act, has been challenged, Lordship. And Lordship, in compliance...
My Lord, before my friend submit, my Lord, I want to say, my learned friend has challenged the FIR. And in the meantime, no stay order. The IO of the case, after complete investigation, submitted the charge sheet, and my Lord, all the PW already examined,
I have found the status. SD also last occasion completed. So how the case will run, my?
At this stage,
No, Lordship, trial is going on, Lordship.
SD is also recorded.
Now the case.
Just a second. 6.8 is fixed for defense evidence. So your petitioner, statement has already been recorded under 313, and that apart, he most probably submitted that he wants to adduce evidence, and accordingly the case is fixed on 6.8
Lordship.
for recording evidence of the defense witnesses. So at this stage, can you say that this petition is can be entertained? It is
No, Lordship.
almost end.
Lordship, now case is still the case is at the stage of evidence, Lordship. Lordship, Lordship, it is quite uncertain, Lordship, that how many defense witnesses, evidence of defense witnesses.
It is up to you only.
Lordship, till the case has not been concluded, Lordship.
No. It is up to you how many defense witnesses you are going to adduce.
No, of course, Lord.
Not with the
Lordship,
performance side.
if my learned friend, suppose at that present this case is investigation stage, even single ground is not here. My learned friend mentioned the false and concocted case registered under section 4 of POCSO. So whole the case is depend upon the witness and evidence. Suppose a case is whatever in the FIR, all are true. Even then no case is made out. Then my learned friend say the allegation is true. Even then it is not offense. Then court can quash my lord. Otherwise no
Lordship,
ground is
today,
here.
Lordship,
Unnecessary.
Lordship, I may be allowed to submit something, Lordship. I may be allowed to say something, Lordship. Lordship, today I want to draw attention of this honorable court, Lordship. Though it is the claim of the informant that the alleged incident took place on the 6th day of 7th of 6th of 2023, Lordship. Lordship, today I have obtained some certified copies of the school in which the victim had been reading, Lordship. At the relevant point of time, Lordship, the victim had been reading in class 2, Lordship. And I applied by RTO application, Lordship. I obtained some documents, Lordship, in which it is reflected that, Lordship, on the day of alleged occurrence, Lordship, the victim was present on the alleged day of occurrence, Lordship. I have obtained certified copies of the attendance register and other.
You make all this sufficient, or you take that kind of very good defense.
Lordship.
That kind of defense you can very well.
No, Lordship. That's why, Lordship.
Your defense evidence.
Lordship. That's why I am submitting before Lordship. My case has merit, Lordship.
No, whatever. We cannot consider this case at this stage. If you have such kind of defense, because already PWs were cross-examined, your statement has been recorded, and case is fixed for defense evidence. Those defense, which you are not narrated before me, that defense can be very well taken at the time of your evidence.
Lordship,
you have the opportunity.
Lordship, one thing, kindly, Lordship, please kindly note, peruse this, and also, Lordship, this case has not been supported by the medical documents, Lordship.
Whatever, we are not on that.
So that's why, Lordship, my case has some merit, Lordship. That's why, Lordship, since all the
this is already
Lordship, since all the witnesses have already been examined by the learned court below, Lordship. That's why may I prayer for Lordship stay of the case,
After
Lordship.
313, very unfortunate, my learned friend was submitting, very unfortunate. A case is already 313 is complete. Now the FIR quashing case is listed today, and learned friend is submitting. Well, very unfortunate. Well, I have nothing to say. Well, the honorable court can pass the order.
Yes, Mr. Bushian.
As stated by my learned colleague, it has already come to me. Everything. I know what maybe my learned friend has stated. Maybe that everything may take it.
Lordship, today, Lordship, I may be allowed to file some additional affidavit, Lordship, in regard to the documents I have obtained certified copy from the school.
Not on that stage. You cannot see all this. It is the end of the stage.
Suppose
this is already defense evidence.
Suppose the witness properly could not establish the case. My learned friend client will be acquitted, my lord. Otherwise, he convict, then he come to the appeal. Now just one date is left. At this stage, any question?
No, how can he say that one date is left, Lordship? Evidence, it is the stage of defense witnesses, Lordship.
How many defense witnesses will examine? That is up to you. But already PW has been finished.
So I may have some witnesses, Lordship. 1, 3, 4, 5, Lordship. So to complete 3, 4, 5 witnesses, Lordship, it will take time, Lordship. So it cannot be said that very soon
the trial will be concluded, Lordship. So therefore, Lordship, this is the very interesting fact, Lordship. On the day of alleged occurrence, Lordship, the victim was present in her school, Lordship. I have the documents, Lordship. So therefore, Lordship, at this stage, Lordship, I may be allowed to file some additional affidavit.
Sorry, we are going to dispose of the matter. It's not entertained. It cannot be entertained. It's not this case. It's not this case. Pardon, Mr. It's not this case. Then you give this case, the defense you have taken that he was present in school at the relevant time of incident. It's very good defense, I'm saying. But you have to take before the trial court below, not before this court, at this stage. Otherwise, it could have been, but not this case is already over, you know. Part Mr. A.K. Ahmed.
A.K. Ahmed.
Part Mr. A.K. Ahmed, done in court for the petition. Also part Mr. Anuddin, done in court. And Mr. A.K. Bashir, done in BPFA and Kashmir State Hospital. This is an application Mr. Ahmed, United Council for the petition that the present petition has been filed for quashing of the FIR. For quashing of the FIR dated 11/6/2023 in registered in Kajigaon, registered as Kajigaon PS list number 49 of 2023 under section 34506 IPC dated October 4 of the box. Mr. Ahmed further submitted that at the relevant time of this is the false and concocted case is law against the present petition, and at the relevant time of incident, he was a student of class 2, was very much available in the school, and he already obtained some documents from the school authority, wherefrom it is that she was present in the school, and thus some false and concocted allegation is withdrawn. For that reason, the present application was filed for quashing of the FIR. Mr. The London Council for the Respondent number 2 submitted at this stage the present petition cannot be entertained at all, and when he obtained the instructions from the client, and it is as per the portal of the session judge. Which session judge? Session judge of Pokrajhar. Session judge of Pokrajhar. The status of the case, and it is seen that the case is at the state of defense after recording the statement of the accused petitioner under section 313 CRPC. As per the report submitted by as per the case status report submitted by the London Council, Mr. It is seen that the case next date is fixed on 6th date 2024 for defense evidence, and accordingly he submitted at this case quashing of FIR and or the entertaining the petition under section 4. It's not at all so in this context, Mr. Ahmed, the London Council for the petitioner submitted, Mr. Bush, the London Edition submitted that case is towards the end of the it is at the end of the trial, and such kind of is not at all meant to be used. In this context, Mr. Ahmed submitted that he has he has already collected the documents as he submitted, and that on the relevant time of incident, the victim was present in her school, and hence he wants to take of which the candidate may be allowed by court to the FIR as well as the criminal process. But hearing this submission made by the Running Council for Process and on considering this the case the report of the case the report of the special your case number is Rachel Pocto
157 of 2023.
But the name of the participants tell us it's not reflecting or what?
Sessions
No,
special.
do you have anything, Mr. Uddin, to say that this case is the reference of this matter? Or
Yes, case number is same, madam.
Yes?
Yes, case number, madam.
Yes, case number is shown.
Yes, case number here.
49 of
2023, Kazigao case.
It's Kajigao.
I have followed from the internet system. My learned friend also knows Merit very well.
Yes, Kajigao, yes.
Yes.
Here only. The last one. A status report of also FOXO number is
Sessions special case number 157 of 2023, Lord. Pokracha.
what?
157 of 2023.
Yes, 157 status report of case report of case number 157 of 2023 arising out Kajigao case number 49. It is seen that all the evidence has already been closed and the statement evidence was also recorded on 12th April and next date is for recording. Accordingly, I find that if any such kind of event is already used addition, there may be a ground of offense and can be produced before the trial court below at the time of adducing this defense witness and which but at the stage of this, but considering the stage of the case, this court is of opinion that it cannot be entertained and accordingly this stands disposed of. It is disposed of. You can appear before the trial court below with that your defense which you have declared.
Much obliged.
Sure. All right, that's all I had.
May I please your lordship? Sir, this is a 482 application, my lord. Basically, an FIR has been lodged by the one person, namely Numal Bora, who represents himself as a member of Assam Jatiyatawadi Yuva Chhatra Parishad, vice president.
FIR was lost by him.
FIR was lost by him. And he himself represented, he is the member of Assam Jatiyatawadi Yuva Chhatra Parishad and he is the vice chairman, and he has lodged an FIR against me that I have engaged a minor child in my shop to carry out cement bags, rods, plyboards, etc., etc. And accordingly, he has received this said information prior to 10 to 12 days before the said incident. And accordingly, he has lodged an FIR before the Jurabat outpost. And accordingly, Jurabat has forwarded the case to the Bokista police station. Accordingly, the case has been registered. Accordingly, thereafter, after police investigation of the case, the police has submitted the charges. And accordingly, the police submitted the charges, and thereafter the learned trial court below took the cognizance. Now basically, my lord, I have challenged the anti-criminal proceedings.
Basically, the moot questions, the panel section under section 79 of the Juvenile Justice Act, and my lord, section 18(1) of the Child Labor Prohibition Act, and as well as section, my lord, that is, I think two sections have been added. That is, my lord, 269 and 270, my lord. So for attracting the penal provision, my lord, under the Juvenile Justice Act and as well as, my lord, the Child Labor Prohibition Act, first to determine who is a child, my lord. So as far as the 2 acts prescribe, the child means a person who below the age of 18 years under the Juvenile Justice Act, and a person who is below the age of 14 years under the Child Labor Prohibition Act. So, my lord, for attracting that, the penal provisions, they have the prosecution as well as the investigation. IO has not forwarded any birth certificate, first of all, from the municipal board or any competent authority. Secondly, my lord, they have not produced any, in the absence of birth certificate, they have not produced any, my lord, school certificate regarding the victim child, my lord. Thirdly, they have not produced any born ossification test regarding the age proof of a child, whether that the victim was child or not. Thirdly and fourthly, they have not produced any documents or any materials at the time of the taking cognizance, my lord, any latest medical test regarding what is the actual age of the child. That is the fatal, one ground for the fatal of that, the prosecution case. Secondly, my lord, the panel section that have been engaged, that has been added and accordingly took the cognizance 269 and 270, my lord. So, for attracting these sections, my lord, basically I have engaged a child, and that child has been, after engaging him, that he has been luckily infected, and that engagement was for the purpose of hazardous employment. That was the basic ingredient. Suppose I engage a child.
Who luckily infected?
That the victim got. That the victim.
Luckily infected?
It means, my lord, I have engaged a child
Yeah.
in a hazardous employment. After engaging that, it amounts to result as a he has been infected or some disease may be caused. So from the entire set of records or the entire documents, it has not reveals that what kind of hazardous work he has been done, and whether that ingredients 269 and 270 totally missing, my lord. Totally missing. Now the main point, my lord, that why they have lost the FIR. What is the basic intention behind it? So, my lord, they have basically represent themselves as a member of Assam Jatiyotibadi Yuva Chhatra Parishad, and before the lodging of the said FIR, they have, my lord, they have demanded money to the shop owner, my lord. That is from the petitioner, and we have accordingly annexed it, my lord. So when accordingly, I have also lodged an FIR regarding this matter, and when I refuse to pay the same amount of money, they have lost the FIR. And interestingly, my lord, the police has also not. The police has also not. The police has submitted the final report when I lost the FIR. When I lost the FIR against those miscreants of the groups of the people that they have demanded money from me, but several occasions they have demanded money from my shop, and my lord, I have a very small shop, and it is difficult for me that they have demanded to 2,50,000 rupees and 20,000 in every month. Whenever they have demanded, it is more difficult for me, my lord. So, my lord, that my case is basically comes under the Bhajan Lal case. The parameters laid down. When a criminal case or when the FIR has been lost, my lord, maliciously or malified intention, and after malified intention in maliciously instituted to wrecking against the accused persons, only on the personal grounds, my lord. that the parameters has been laid down, and it comes under that parameters, my lord. So, thereafter, my lord, I have one point, my lord. I will submit. I will not take more time, my lord, because already I have covered all my case. So, running page, my lord, kindly see 11, my lord. So, only one point, my lord. Then that is the point number L. So, I will just point out that point, my lord. So for that taking cognizance of the offence under section 79 of the Juvenile Justice Act 2015, there is nothing in the prima facie material against the accused while having charge of the minor victim. The prosecution has to fulfill all the ingredients of that offence. Basically, the ostensible procurement of the minor child. That is the basic ingredients, minor. If we see the sections, that ostensible engagement is required. From the entire set of 161 statement, and when the police has investigated, neither single iota of, not the evidence, sorry, my lord, single iota of materials available in the record that I have engaged that child as an ostensible procurement. And moreover, my lord, to taking cognizance that minor child is required to be proved, and thereafter, my lord, it is also to be proved that purpose for procurement was for hazardous employment. That was the basic ingredient, my lord. Thirdly, my lord, it is also to be proved that after such procurement, the accused kept the minor in bondage and withheld his earning. So where is the document, my lord, that I have engaged that child and thereafter I have withheld his earnings? Even if you presume that I have engaged a child in my shop, but prima facie case has been they have made out falsely or badly, but where is the document, my lord? That I have engaged that child and after his money I have used in my own purpose. Where is the document? Who is stated? And the entire 161 statement, they have not the neighbors of the shops or the persons. They are from the outsiders, my lord. So, even though my lord is awarded, the case 482 is applicable if your lordship that is awarded, that the Sarvananda Sonowal versus CBI, where the lordship says of our Guwahati High Court has categorically stated that a criminal trial is divided into 4 categories. Firstly, after taking cognizance of the FIR or complainant. Second, the framing of the charges. Thirdly, my lord, that is the receiving of the prosecution witnesses. And fourthly, that is the if the defense has adduced evidence till the pronouncement of the judgment. Now, my lord, I come before your lordship as far as possible after receiving the copies and before framing of the charges, my lord, also, with all due respects. I have no any intention to delay after framing of the charge, after receiving the charges I have challenged. So after receiving the documents which has been provided under 207 of the CRPC, I come before your lordship that this is not a fit case to facing the trial accused because it amounts to miscarriage of justice and it amounts to miscarriage of justice. This is my humble submission before your lordship. If I just point out only the basic points, man. So, my lord, the next date fixed for CC hearing, that is 26, probably, my lord. So, if the lordship will kindly see the first order, that it has been observed that after receiving the LCR, the court will pass the interim prayer also, my lord. My interim prayer. That is, my lord.
You are for final hearing or interim prayer?
But today I also pray for final hearing also, my lord. If my lord, if my lord is required for final hearing also, then it.
But because what I am saying that if you are saying it will be, if we keep it, suppose CAB.
Oh yes, my lord.
It may not be there may not be any order of stay. In that case,
Yes.
otherwise when the case is fixed?
For pronouncement of judgment.
No. Your
All that case has been fixed for CC hearing.
CC hearing.
Yeah,
When?
exactly. Learned Trial Court of the Judicial Magistrate, Kamrup Matrimonial.
When it is
26. 26/7, my lord.
26th of this month.
Sorry, this month, my lord. That is the difficulty.
I don't know. You have submitted.
Yes, Lord. I have done for the LCR. That was fixed for hearing on third. Earlier occasion they had taken some time, and it is now fixed for, as my learned brother has stated.
Because, my lord, last occasion this matter has been come before your lordship. That the court also, at that time also the LCR is not available. So that's why, so I have also, that's why, my lord, we are difficult at that time, because there is an observation also in the first order also. That's why, my lord, we have taken the time. Otherwise, from the entire set of records, there is nothing, my lord. From prima facie, it is clear that the entire case is based, they have maliciously instituted against me, my lord. That is the basic.
So what I'm saying, suppose it was an order there, it was there that the NDPS may be considered after receipt of case.
Lord.
But that time there was not there, so the order may not be considered. But case can be disposed of finally. But what I'm saying, if I keep it as CAV, because lots of matters are there.
Yes, yes, Lord.
In that case, there may not be any stay.
Yes, yes.
So, what do you want to do? That's what.
I leave your lordship, whatever may be.
No, it may be disposed of finally, no issue.
Yes.
Then, what have you done?
Yes, Lordship, here the thing is that, and there is an FIR, and then thereafter investigation completed such a file, cognizance taken, and at a fixed for the hearing on search. Now, my learned friend has stated on the questions regarding, as because it is regarding the child raper, he has questioning on the part of the investigation regarding the birth certificate or regarding the age of the victim child. That is in question in his part. Other than that, Lordship, there is no other question in this matter, because even from the record itself, there are sufficient witnesses are there who has stated there is a when the that is the victim was recovered, he was in handed to the sideline. They have also some documents. All these things are Lordship there. Only one point stated by the petitioner is that there is no medical examination in the part, and there is no this is the birth certificate and all this. And now the question is that when a child labor is there, whether in most of the cases it is difficult to get the birth certificate. It is in question because why a boy is going for earning wage in that particular age. Well, Lordship, in those matters, these are the matters of trial and as because he may go for the framing on search, all these issues, whether this section will come, this section will not come, he may get an opportunity during the hearing of such and he can file the discharge petition in this regard also. He will pray for discharge also. Rather than the Lordship completed the investigation, and even if, regarding the cross FIR, what my learned friend has stated, in that regard, police submitted an FIR, and FIR they have mentioned in a different way, as because that child labor practice was going on, they protest before them, and because of out of that only that FIR was lodged. That was the stated in the FIR by the police. My lord. Because one, there is no question that whether there is a child or not. The question is not about the child, there is a boy. Availability of a boy in the shop is there. Now my learned friend is questioning whether he is a child or not, whether he is a juvenile or not. That is in question, that is his part. But there is a boy, there is no dispute.
What is the statement recorded?
Yet to my, no, I have to have a record. I have to go through it. The CD is not available. Among these documents I have already annexed. And Lordship, in the LCR I didn't get the CD. That part is not there.
What part there?
One part, not entire.
Here, you are saying the statements are not available.
Statements are not available. Because I have stated from the petition itself.
Yeah, whatever maybe they have stated, I have
Then
written.
so it will be
Moreover, my lord,
second statement.
Because how the investigation was proceeded.
that is the, I have, with all due respect, my lord, that's why I am saying, they have make out a case, but it is not a clearly visible that this case made out, because my lord, they have colored a case.
No, coloring will come later on.
Yes,
but
ma'am.
question is that
But perusal of the
CDP
is required,
is
Lord.
not available. That we are on that.
Yes, my lord. My lord, my learned senior friend has already stated the 161 statement of the statement,
Where
but
from you are saying 161?
from my
from your
itself,
petition.
yes, my
Lordship.
lord. I
From
have
the
annexed
petition.
all the documents what they have provided
But
me.
here
my
it is not available.
That is not available, Lord. And that is, I think, for the purpose, perusal of that part is necessary, Lord,
Yes,
to find out.
one document. Or my lord, when
Hard copy? Hard discharge.
yes, sir, my lord.
What is K Bush?
Oh, sorry.
K.
Depending on respondent. The answer has already been received, but it is submitted by Mr. Bush that the statement of the witness recorded in section 121 are not available in the here. Scan copy that gets that the statement recorded under section was after the Mr. Sharma also had back and was submission in that it is the consideration charge.
Yes, ma'am.
Further proceeding in case number 8 your petition proceeding is state in the of
Yes, ma'am. Deeply obliged, ma'am.
and we are calling for the
Yes, ma'am. Yes.
case diary updated case
Yes.
diary with along with all
Statements and-
statements.
Yes, Lord.
Yes. Regarding this aspect, my lord, I have submitted that when the learned trial court below, if the matter is pending or charge hearing or CC hearing, that learned friend stated that I may file a discharge application or I argued it. But Honorable Apex Court also clearly stated that when there is a miscarriage of justice in para number 16, my lord, the Honorable High Court can exercise 482 and quash the proceedings, ma'am. That I have submitted. With deeply obliged, ma'am.
Okay, production
My lord,
race matter petition.
Very
So
clear.
production list, you are saying on the morning hours that
What's the
he is
modification?
not in a position.
Lordship.
He is suffering from this one. Is it?
No.
So you are on which
My
case?
Lordship, I have filed an IA in BN number 2011 of 23.
Huh? PA number?
2011 of 24.
Again, why?
Modification of modification in order dated 15/7, Lordship.
What is it? Why?
There is condition number 3, Lordship. I have annexed the order, Lordship.
Yes, whatever. What you want? Why you want to go for?
Lordship, in this case, petitioner hails from the state of Meghalaya, Lordship. Lordship, in condition number is there, he cannot leave the jurisdiction of Kamrup Metro without prior permission. But he is local person. Lordship may direct to appear him before the
Monday, but it will be listed on Monday or
My lord, item 46, my lord. Only problem is, my lord, I may be given 7 days time to take fresh step and also allowed to file the correction petition. My lord, item number, my lord, lordship, with regards to item number 47, my lord, this renders my lord infructuous because of an agreement with donor. Lordship may take up the next week, my lord, the date may be fixed.
that will adjust.